APR Department. Hear ye. All persons having business to do before this court will adjourn and give their attendance and they shall be heard.
Good morning, everyone. You may be seated. First case on for oral argument is 519, People versus Bloodworth. Good morning, Counselor.
Good morning, Judge. May it please the court, Linda Campbell for Allie Bloodworth. If you'd like, I'd spend the most amount of my time on the first point, which is the
And I think that's a good point to spend on this.
ineffective assistance of counsel argument. If you look at this case, what you see is kind of the defendant taking charge where his lawyer is not. The attorney files what I think could really readily be characterized as boilerplate motions, and he doesn't address the speedy trial argument at all in those motions. So the defendant files his own pro se, inartfully drawn, but it's a pro se motion, where he clearly raises the speedy trial argument. Subsequently, the attorney, whether by being pressured by his client or otherwise, files what could be loosely referred to as a letter motion.
The core of the issue is this, and you pointed out in your brief. It was filed on January 8th, the indictment.
Correct.
And by the record, you've pointed out that announcement ready for trial was 7/14/14.
Correct.
And the judge down below miscalculated the number of months in between.
Correct.
Which was readily apparent that it was more than 6 months.
Correct.
And counsel was there at the time, never picked up on it, never objected to it, and it would have been dispositive, potentially, or really dispositive of the action.
Correct.
They seem to be arguing that somehow or another the June announcing ready for trial, the indictment that they filed, that was the actual core date of time, which would bring it within compliance.
That's the argument they're making now.
Yeah,
They did not make that argument below at all. As a matter of fact, those dates, the January 8th date as the commencement date, the July 14th date as the ready announcement date, are gleaned directly from their response to the letter motion that counsel ultimately filed. So that's clearly an argument that was not presented below. Furthermore, even if one were to take that argument and dissect it a little bit, there's nothing other than that bare allegation and the blank line on the bottom of the indictment that says the people announced ready for trial without any indication of the date on which that was done, initialed, or in any way subscribed to by either an ADA, the district attorney, the foreperson of the grand jury, or whatnot.
Or an indication that they advised the defense that they were declaring that they were ready.
Correct, Your Honor, correct. So I think all in all, this was a meritorious speedy trial motion that should have been advanced by certainly the defense attorney once his client had made the motion. And the error in the court's calculation of the time passage clearly should have been picked up upon. On that basis, I would ask the court to reverse this conviction and dismiss the indictment. Turning secondly to the manner in which the court handled the defendant's motion to withdraw his plea, if the court does not otherwise reverse on that first point, it was peculiar at best, at least in my review of this. Defendant makes the motion to withdraw his plea, and the court in response says, well, Mr. DA, let me see the videotape of this robbery. So if you will, in fact, the court is putting before itself some evidence that would be contrary to what the defendant's motion is, which is an actual innocence basis. And apparently, from the record, it seems, had that videotape played on a laptop or some piece of equipment there in the courtroom for the defendant to see, and on the basis of that videotape denies the motion and they proceed to sentence. If you will, that's kind of part of a hearing. He didn't give the defendant a further opportunity to present anything he might have had in furtherance of his motion, and he certainly did not substitute counsel who the defendant was complaining about at that particular point, both of which I think could be viewed as wrong. And if there are no further questions, I'll rely on my briefs.
Good morning.
Good morning, Your Honor. Brad Oster for the people. Our position here has to be that the motion that was advanced by the defendant pro se really was not an adequate motion. There was not enough detail with regard to the 30-30 argument in terms
I think where your problem exists, or at least that I view it, is it's clear from the record the court puts the actual dates in that are effectual and then miscalculates the dates. And that's where the counsel really focuses in on, that if you did the math, it's simple, and it was right before the attorney, and it would have been, and if correct, other than the other exclusion of time, whatever, it would have been dispositive of the issue. And it's because it's an unusual situation that it's got to be egregious enough for an effective assistance to result. And this appears to have been what could have been dispositive.
Right, and I think our review was perhaps a little hampered just because there was no real discussion about excludable time or any sort of reason why there might have been less than the 6 months.
Well, the people never claimed any
No,
entitlement to credit for any time,
No, and
right?
the people's written response, we did not address the actual, we really only addressed the constitutional claim. It appears.
Right, so your argument on appeal, really, you come up with an argument that says the indictment was filed, the DA had an unchecked box that said the people are ready for trial. That was on June 27th. He was not, this actual statement of readiness in court was not until July 14th. Your argument on appeal appears to be that that's a valid statement of readiness, even though it wasn't sent to the defendant or his lawyer, because under Kenzia, under that footnote, it says the off-record statement of readiness is still valid if it's communicated promptly to the defendant or his attorney. And your argument is that 17 days is prompt. 17 days being the time from the indictment, that notice, the unchecked box, to the arraignment on the indictment where they actually announce readiness, that is prompt. Am I accurately?
I would make that argument given the fact that it would appear that the delay between the filing of the indictment and the actual arraignment was ostensibly more of a, I don't want to call it court congestion, but just more of a court scheduling
But in your view,
issue.
17 days is prompt.
I think given the circumstances here, yes.
But wouldn't they, even assuming it was 1 day later, don't they have to say, the statement of readiness when he was arraigned was, we're ready for trial now. As Ms. Campbell points out in her reply brief, wasn't the DA supposed to say, that statement of readiness, the unchecked box that we didn't send to you, that was a statement of readiness back then. Don't you have to do that?
Well, I think that's, our argument is that the filing of that document with the court, and then what I would also argue the somewhat prompt notice to defense counsel when everyone appeared again in open court, that did essentially stop the clock on the 27th.
You would acknowledge that these are arguments that weren't even made below, and you're straining here.
It is not the most ideal set of facts. I have to.
It's the facts you're stuck with.
Right. I do want to very briefly just bring up one point that was not briefed by the people. There is case law to suggest that a claim for ineffective assistance of counsel is foreclosed by the defendant's guilty plea when he does not allege that the plea negotiations or the guilty plea itself was affected by essentially the ineffective assistance. Right. I recognize, of course, that my colleague hasn't had a chance to respond to that, but that is case law that stands.
Okay. Thank you, counsel.
Thank you.
521, 522, 527, People v. Osman. Good morning.
Good morning, Your Honor. Appearing for the defendant, Tom Diop. There doesn't appear to be a dispute that a stun belt was required to be worn by the defendant here. The judge who heard the motion seemed to pretty much recognize that. The people did not contradict that allegation. The real issue here is that there was no objection by the trial judge with respect to wearing the belt. My obligation is to convince this court that notwithstanding that error, the conviction should be reversed, or at the least the case sent back down for hearings. My argument in that regard is bifurcated. I have two separate arguments. Number one, it was ineffective assistance for the attorney not to have objected to use of the stun belt. Number two, we have here, under these unique set of circumstances, a mode of proceeding error, which means that even if there wasn't an objection, you would still hear the issue.
This took place before Buchanan was decided, right, this trial?
It did take place before Buchanan, but the direct appeal is still pending, so Buchanan precedent is applicable with respect to these cases. And there was plenty of precedent.
Oh, no, I don't disregard that, but with respect to the ineffective assistance of counsel claim, it may be relevant that Buchanan had not yet been decided by the Court
It
of
may be
Appeals.
relevant. However, there was plenty of other case law out there dealing with restraints and stun belts. Furthermore, this is a case where the defendant specifically went to his lawyer and said, I want this thing taken off. And the lawyer responded by saying, there's nothing I can do about it. Not only that, we have a situation here where the defendant had to testify while wearing the belt.
With respect to the Court of Appeals, when they did rule as to the stun belt, the error was not stating on the record the reasons for it? Isn't the court supposed to state?
Oh, that's
The
correct,
stun
yeah.
belt can be utilized.
It can be utilized. The judge has to give on the record explanations as to why he's going to utilize
And he
it,
didn't.
which was
And he
not
did,
done.
yeah. Yeah,
Not
this
only
judge just
that,
had it as a policy.
he had it as a policy, and we know that the judge in this case was also the judge in the.
Of Buchanan.
We had,
Right.
Buchanan came from
We
this
had-
court.
in the Buchanan
Well, Counselor,
case.
what you seem to do is you recognize the problem you have with the preservation, because they made it clear. And we've had a number of cases, at least there's a number of cases that dealt with where it's not been preserved. You've seen those, there's been cited to, where we haven't found ineffective assistance.
And I'm ready to distinguish that and tell you why you need to do it this time. And this would probably be a case of first impression. The quintessential case on this is Schrock, decided by the Fourth Department. It's a very detailed case, more detail than you're going to get even from Court of Appeals precedent on this matter. In Schrock, you had a 440 motion made with respect to a stun belt. The claim was the lawyer should have objected to the stun belt. Goes up to the Fourth Department. The Fourth Department says, we're not finding ineffective assistance here due to failure to object. There's a distinction, though. In Schrock, the record reflects that the defendant had a conversation with his lawyer about the stun belt, and the defendant said he didn't have any problem with wearing the stun belt. He registered no objection to his lawyer.
But
And this,
Schrock, let me just, because I was on Schrock, and I'm very familiar with Schrock.
oh, you're going to know more about it than me then.
I don't know about that, but it's been a while. But I do think with these failure to object to stun belts in the Shackles cases, it's not as though an objection would have gotten the relief, would have meant that there had been no stun belt or no shackles. In other words, Buchanan in these other cases didn't say you can't use a stun belt or shackles. All it says to the court, to the trial courts, is that if you do, you have to state the reasons, and they have to be legitimate reasons.
Right.
So in Schrock, there was ample reasons.
Oh, there was more than ample.
He, as I recall, he tried to kill a police officer. He tried to escape many times.
While trying to escape, he attempted to murder a police officer.
Tried to run over a police officer, right.
And it's the escape that's the key to the stun belt. In other words, if there's a record of a defendant trying to flee, escape, and so forth, that's a stronger argument to use the stun
So in
belt.
Schrock, even if there had been an objection, I think part of the rationale was, if the lawyer had objected to the stun belt,
He would have lost.
the court would have said, okay, I'm going to put the stun belt on because he's a violent man who's tried to escape. Here, that's the question in my mind is, an objection.
He would have won.
Your client.
He would have won.
The crime itself, I
Let
don't think
him
we can
finish,
look at,
please.
I don't think we look at the crime itself, but this was a brutal murder where an innocent person got his head beat in and brains splattered all over the place by a log. Now, I know your client claims he didn't do it, but he was charged with doing it. But I guess your argument is that there has to be more than just a brutal crime. There has to be some other indication?
In Buchanan, it was an equally brutal murder, the strangulation of a 14-year-old child, okay? And the Court of Appeals held that you cannot make the use of a stun belt a routine adjunct of a trial simply on the nature of the case.
When you say that he would have won had he made the argument here, he may not have won at the trial level, but you're saying ultimately on appeal
he would have won on appeal.
Because this trial judge had a policy, so
Right.
it probably would not have, or, it's likely it may not have made a difference at the trial level, but
It probably wouldn't, because given his policy as enumerated in the Buchanan case, he would have probably lost at that level. I think this is also the first case where you're talking about a stun belt being used while the defendant takes the witness stand to plead for his liberty. I think that makes it a very, very different circumstance. People versus Negron, 26 NY 3rd 262, generally just stands for the proposition that you can raise via a 440 motion a claim of ineffective assistance predicated on a failure to object, because the people seem to be pressing that issue significantly. Then the secondary argument on this, namely mode of proceeding. Again, in Schrock, this court held that a mode of proceeding error was not found with respect to use of the stun belt in that case. But Schrock also laid down a number of criteria under which the possibility could exist at some future time that a mode of proceeding error could be found. And one of the criteria that Schrock cited to, which in turn cited to a Court of Appeals case, was that if the use of the stun belt affected the entire trial from start to end, in other words, it wasn't one incident here or there. Remember, in Schrock, he only wore the belt for the testimony of a single rebuttal witness. Here it was the whole time, and it was while he was testifying. And he's constantly looking at the guards to see whether they're going to activate that thing. All right, he has a huge box in his back that is part of the stun belt mechanism, so that when he sits in the chair, his back is arched. He can't sit comfortably in the chair. The jury is focusing on him while he's testifying, focusing on him, okay? There's a real possibility that jurors could have sensed that there was some sort of restraining device that was being used here. That probably wouldn't have been a problem had he not testified. But once he's on that witness stand, the jury's going to focus in on him like a laser beam. And jurors aren't stupid. I mean, they're going to pick up on these kinds of things. So that's also another distinguishing factor. And again, as Judge Lindley had pointed out, one of the things in Schrock was that they said that this was purely procedural. Here it's beyond that. It's not just purely procedural. Even more so in Buchanan. Buchanan did not testify. And it was reversed. Here he testified. There was a Court of Appeals case cited by the people in which they said that mode of proceeding error was not applicable with the stun belt case that came to them in that circumstance. But in that case, the record also reflected that the defendant had affirmatively consented to wearing the belt. So under those circumstances, I don't think you would have a mode of proceeding error.
Do you want to get to your time's kind of running out? Do you want to get to your issues with the prospective jurors?
Yeah, I've got so many points in the brief.
Well, you have limited time with so many points.
Okay, I appreciate, the one I really would like to talk about would be, there's two juror issues, but one is Juror Summers, who specifically said, I can't be fair in this case, it's a murder case, I can't give the defendant the presumption of innocence. All right, there was no request for a cause excusal of this juror or the exercise of a peremptory challenge. I spoke with the defense attorney about that and asked him what happened here. And he had the transcript because I sent him the transcript. So it wasn't as though he was speaking out of a vacuum, and he had
Is
plenty
it clear that the peremptory challenges were exhausted here?
That's another problem that we
Well,
have.
that's the problem with the hurdle we have.
That's the problem. That's the other juror, Jenko.
Jenko.
Who said,
Here, your argument seems to be specifically to the ineffective assistance.
it's ineffective assistance, but we also have a problem that number one, the lawyer should have made it clear in the transcript that the preempts had been exercised. That wasn't done. For some reason in this court, they didn't state on the record each time a preempt was exercised. It was handed up on slips of paper. Mm-hmm. Okay, so in order to determine whether or not all the peremptory challenges have been exercised, you've got to find that piece of paper. And I went through, heaven and earth. I went down there. I personally interviewed several clerks, okay, in person, on the phone. I mean, I got...
We recognize that. They're not found.
They're not found, and it appears that...
So we go back to the question that was initially asked by my colleague, is that, do we have anything in the record that establishes that he exhausted his preempts?
The only thing you have is the defense attorney's affidavit where he surmises that the issue was preserved because he says his recollection was he walked out of that courtroom thinking that I got this, because he denied the Jenko challenge, meaning that he exercised all his preempts, but he couldn't swear under oath that in fact all the preempts had been exercised. All he could give me was his indication. So then what happens is you fall back onto the case law that I cited that said that if a portion of the record has been lost, in this case, not the transcript, it's the court lost it, okay? That's more egregious. It's more difficult, I think, for the prosecution. We're not talking about a stenographer, and they have a policy, evidently, of throwing these files away once they scan them.
I've never heard of doing peremptory challenges off the record like this.
I never.
I guess slips are on the record, but it's a dangerous procedure. And you're putting on pieces of paper that can get filed somewhere, and then they're lost, and now we have no idea. And nobody, but the problem here is that there was a 14-year delay between the conviction and the perfection of this appeal. And I could see the DA arguing, well, if you had perfected it in a more timely manner, maybe the slips would have been found, or memories would have been better, because by the time you got to the issue, nobody remembered anything. And so why so long? Why 14 years?
First of all, we don't know that the delay would have had that kind of effect. In other words, if their policy is once we scan this file, we throw the hard copy away.
Well, no, the point is this, that maybe the copies are still gone, but the memories of the judge, or the counsel, the prosecutor, we get this all the time, and we send them back for hearings. I mean, even if we sent this back for a reconstruction hearing, we know they don't exist, and we
Right.
know nobody's got a present recollection of it. So the delay in and of itself of 14 years, as opposed to 2 years or 3 years, obviously increased the possibility of someone's memory. And then, you know, and these are the things that I struggle with this case is the length of time that took place.
All I can say is, first of all, I didn't have the case
We recognize
from
that.
inception. I would not have delayed 14 years. Look, the people can always make a motion to dismiss for failure to perfect at any time, okay? If this had been assigned to legal aid, this wouldn't have happened, because legal aid would have picked it up, and they would have gone, and it would have been in their docket. Although, even with legal aid, you'll get a year or a 2-year delay, and you could have still had this problem with a year or a 2-year delay. As often happens, the clients decided to hire a trial attorney who was on TV and supposed a big shot in another city.
So with the passage of time, who should bear the effect of it, the prejudice of that time being lost? Like the judge presiding just said, with the fact that you can't even utilize memories now because of the passage of time.
I would say in this case that the burden has to be borne by the people, because this is the clerk, this is the government that destroyed its own file. On a murder
But with
case.
respect to, but what about the perfecting, and that the defendant could have moved this case along much sooner than 14 years?
So could the district attorney have done the same thing by
But it's the
motion?
defendant's appeal.
I understand that it's the defendant's appeal, all right?
Okay.
But we also have a situation where, in other words, if there's an individual private sector stenographer, all right, who loses her notes or the notes are lost, that's one thing. But this is the court system that destroyed its own file on an appeal of a murder conviction where the direct appeal hadn't even been perfected yet.
Probably one of the biggest murder convictions in this county's history.
It's a big deal. I'm not disputing that. Yeah, all the more reason to hold on to the file. All the more reason for the district attorney to, you know, make a record of it too. And the other thing is, you've got prior appellate counsel who, you know, wasn't proceeding as she should have been proceeding.
So
know
I
what
think
to
it's
say.
you should start to wrap up, Counsel.
The only other quickly on Juror Summers, she had indicated that she could not be fair in this case. She should have been excused for cause. She flat out said that this is a murder case, and I can't give the defendant the presumption of innocence.
I give you that, some of those issues that you've raised today are troubling.
Now, that wouldn't depend on the jury slips, Juror Summers, because there should have been a cause request. If that cause request had been made, it would have either been granted or the conviction would have been reversed. You know, but she sat on the jury, and she should have been excused. And the defense attorney initially had said, when he looked at it and I asked him about it, he admitted he made a mistake. I asked him, will you sign an affidavit saying you made a mistake? He initially told me he would. Then when I sent the materials down and the affidavit down, he pulled back on that.
Right?
Yeah,
The
it
only
is.
way that that's not ineffective is as a counsel.
I'm sorry, I didn't hear you, Your Honor.
The only way that is failure to challenge, either for cause or peremptorily, juror summons, prospective juror summons, the only way that's not ineffective is if there was some other thing she said during voir dire that gave the defense attorney and some indication that this is a juror that's going to be favorable to the defense. Because, you know, the voir dire covers a lot of things. Maybe he thought maybe she could have been a social worker, and the defense lawyer said, well, I thought you might be sympathetic to my client, or who knows what else reasons. That's the only way it's not ineffective. And we don't know what the lawyer was thinking. It could have been he just made a mistake, but he won't sign an affidavit. So we don't really know, I guess.
Well, I asked him that question, though, and that question was posed to him in writing by me, and he signed an affidavit saying that he would need to see the missing slips of paper to refresh his recollection about why he didn't excuse Summers. But that doesn't make sense.
doesn't
Because
make
the
any
slips of
sense.
paper simply indicate the names of the jurors who were excused. And he had originally told me he did make a mistake, and he originally told me he would
We have
sign
to
it.
deal with the record in front of us, Counselor.
Well, you have my affidavit. That's part of the record on the 440 motion.
Okay, thank you.
Thank you.
No, excuse me, Counselor.
Oh, I'm sorry.
Good morning.
Good morning, Your Honors. John Zarowski for the Chautauqua County District Attorney's Office on behalf of the District Attorney there. So, in terms of a delay, I'm well aware of the delay because in my career, I moved back to Chautauqua County after starting out in the Westchester County DA's office. And this trial in 2001 was going on when I started in the office. So my entire career in Chautauqua County has been how long it took this case to get to this court. It feels like forever to me, of course. Raised a family, done everything, but we would be in a far better position to have some of these answers if this had been perfected in a timely manner.
Whose responsibility was it, though, to preserve the record?
What part of the record specifically?
Those notes.
The notes, I think that would be the court's responsibility. I think that is the responsibility of the court. It was a relatively unique system that when I moved back, I wondered how it all worked, but I did see that they took the sheets. You know, I'd been in Westchester County, they didn't have any sheets. It was all a conference. I mean, they took the sheets, they did keep them. But what I would note is we've got the record that we've got, and there's no indication that all the peremptory challenges were utilized by the defense.
We don't know that because the court lost or destroyed the sheets.
Well, there is.
First of all, I mean, I've never seen, we all presided over a lot of jury trials, and as have you. Have you ever seen a judge do peremptories off the record like this? With a piece of paper that gets stored, Lord knows where, and then disappears?
Well, I would say that this is the only case that the papers have not been located. And I cannot offer an explanation for that, but it is the only time. I mean, they're not on the stenographic record. Those are made court documents. They're part of the record. And it is the responsibility of the defense. I mean,
But that's the point. Normally, jury selection is done on the record. There's a record when these challenges, if they had been stenographically recorded, we wouldn't have the issue we have now.
You mean if the challenges themselves have been?
Correct.
Yes, I understand that. Although, well, and minutes can be lost as well. I mean, unfortunately, I had the experience of reconstructing a murder case once downstate too that was quite a chore.
Counsel, you were about to say about what we did have in the record regarding the peremptory challenges. What do we have that tells us anything about the peremptory?
Well, we don't have the defense attorney asking for additional peremptory challenges, which is always available at the discretion of the trial court. And the other point I'd like to make is, if this court has reviewed the entirety of this record, to claim that this attorney's ineffective for picking one or two or three minor things, he was tremendously effective. In fact, I just read the record because Ms. Schaefer, who prepared the brief, left our office for a different job. And this was a slugfest of a trial. Ed Fagan was a terrific attorney, and it's evident in that record. Those two attorneys go toe-to-toe. And many of the errors that the defendant now claims, the appellant now claims, are really responsive to the tactics of defense, which are strong. It's fisticuffs in the courtroom. It is. And it's 2001. And he fought every inch of the way.
Right, but I don't understand how that deals with Jenko. There was an objection to Jenko for cause, right? Prospective juror Jenko? Jenko made some statements that reflected a bias. There was a challenge for cause. It was denied. We know all that.
Okay.
The only question is, if the defendant didn't exhaust his preempts, then we can't do anything about it. So you're talking about it was a slugfest, and
Well,
yeah, he made these arguments. The argument is that the court should have granted his argument. The fact that he did well on all these other issues doesn't excuse the fact that the court made a mistake in denying his challenge for cause, does it?
No, that would not. But what you had been speaking about another juror previously.
Summers is different, yeah, I'm talking about Jenko.
And claiming ineffective assistance of counsel because he didn't seek to have her removed.
And as we stated earlier, it's a different standard. We're looking at Jenko. If he didn't exhaust his preempts, then Jenko's a non-issue.
Correct, Your Honor.
Okay. But when we get to Summers, there come two different, obviously, jurors. We're dealing with that her statements were so biased that and they said in the case, it's ineffective for not in and of itself exercising preempt.
On Summers.
Summers, that's what Judge
Summers,
Lindley
yes.
is referring to Jenko.
Yes, and what I would say is this attorney, who clearly showed his skills, would be my belief, they can pick any juror they want, any juror they see fit, any juror who makes eye contact with them at the right time, any juror who nods at the right time. There's a chemistry. And, this, faced with overwhelming evidence of guilt, this attorney picked a strategy. And, who are we? We don't have his statement that he made a mistake on the record. We don't. That's not part of the record.
No, your point, though, is, at least with respect to Summers, is that there may have been something, as Justice Lindley said earlier, there may have been something that she said, outside of the issue relative to the gruesome photographs, that this lawyer liked.
When the court was questioning her earlier, because I assume she filled out some sort of a form that indicated that she knew someone who'd been convicted or a victim of a crime, the court asked her questions about someone who worked with her husband and who was a family friend who was convicted of selling marijuana, I believe it was. Certainly that could have been something that the defense attorney would have thought would be beneficial to have a person who knew someone who was convicted on a jury.
Yes, and knew that they were human and that it could happen.
Yes, that they were a friend.
Yes. And I have, when I've sat through jury selection, I'm often surprised at a defense attorney not moving for cause on somebody who may have said something that would at least make an argument for it. And often in a smaller county, it turns out they may have recognized them, know who they are a little bit, feel good about them, feel good about the community that they're from, the town, the village that they're from, their address, their...
We recognize there's a number of reasons.
Yes.
Why don't you address the stun belt issue that became...
Your Honor, I believe that this court's holding in Schrock, it would indicate that it's not of motive proceedings error in this particular case. The record is moot as to the stun belt. I don't believe that there's any reason to somehow distinguish this case from others because the defendant testified with the stun belt. There was no complaint. There was no complaint registered. The record is silent as to that. In fact, the record is silent as to the use of a stun belt. I was not in court. I had been assigned to a city court, so I don't have any recollection myself, and I was not familiar with that practice at the time. I do not believe that it would be ineffective assistance of counsel to not have objected to that.
If it were post Buchanan, it's a tougher argument for you. But I guess your argument is that a lawyer can't be faulted for failure to anticipate a Court of Appeals ruling that's coming many years later.
That's correct, Your Honor, yes. And Buchanan I'm familiar with. When it was sent back by this court, it became my responsibility. So I'm very familiar with it. And yes, it would not be ineffective. In fact, I think to some degree, there may have been defense attorneys at the time who would have preferred that as to shackles or something that was visible and maybe been satisfied with it. Again, we have no voice of dissatisfaction in terms of the stun belt, and it would be our argument that it is not preserved.
Okay, thank you.
Thank you, judges.
We're not calling this case again.
No, I did it all at once. When I read out the three numbers when I called.
Thank you, Judge.
I figured you'd want it that way, it'd be easier to get up.
Thank you, Judge.
523 People B. Varney.
Judge, you said Renee?
Renee, grab it.
Yes.
Good morning.
Good morning, Your Honors. Stu Weisman for the appellant. Your Honors, what started out as a garden variety DWI prosecution somehow morphed into a series of errors which, at least in my reading, appears to have affected the fundamental fairness of the trial. As this court noted 43 years ago in People versus Balsano, once it's concluded that an essential element of a fair trial is missing, there must be reversal regardless of whether a fair trial would have produced the same result. And as set forth in my papers, I think there are three meaty subjects or areas that support my conclusion. The first one, not as much, but certainly the last two. The first one was allowing the entire testimony of the 911 operator over objection, not only for best evidence.
Well, it wasn't offered for best evidence, though. It wasn't offered for best evidence. It was offered. It was offered as an excited utterance, wasn't it?
Well, initially the judge ruled that it was best evidence and gave supporting cases. I think the Vecchio case on that. Then it turned into, well, it's excited utterance excited utterance or present sense impression. Both of those, as a matter of law, are just not applicable here because the prosecutor...
She's riding in a car, and she's telling the 911 operator, she said she thought he was going to kill her afterwards when the police come, and there was some fighting between them, and it's alleged there was assaultive conduct upon the victim, and you're saying what she may have said during that time would not cause her to be in such a state that one could say she had excited utterances?
No, not under the facts of this case. First of all, the telephone call was not spontaneous.
Spontaneous to what?
Spontaneous with any of the events that occurred.
I think you're referring to spontaneous to the DWI. What I think is the more relevant analysis is whether it was spontaneous to the assault in the motor vehicle.
But the call was not made in the motor vehicle.
No, it was made afterwards.
She got out of the motor vehicle and ran to the road, it's stated. She got out of the vehicle and she called the police.
Well, it wasn't, but there was a time lag, okay?
So she should have made the call while she was still in the vehicle next to the person who had just assaulted her?
No, because what happened is that there was a passage of time when the alleged assault occurred. He drove into a field, parked the car, then she went out.
So are you arguing that these weren't, there wasn't a continuum of conduct here? Are you arguing that there was some sort of lapse in time where she just sort of hung out in the field after he had crashed in there?
Well, there was a lapse of time because she didn't run out of the field. She could barely walk, and she, according to her testimony that's in the record, She didn't call 911 because she was afraid, and she said she wasn't afraid of him when she made the call,
Let me short
but she
circuit.
wanted help off the road.
Let me short circuit this. This is where I can't even follow your argument. We have a 911 tape. There's, my view of it, there's testimony as to why it was destroyed in the regular course of business. Now we have the 911 operator testifying, and we have the victim of the assault testifying. So we have everything before the court. And so, you know, in my view here, this isn't a tape that we have somebody testifying, a 911 operator, and that's it. We actually have the victim who made the call, who says specifically what happened. He did this, he did this, he did this. I called 911, and what she did. So I think you'd better spend a little more time, maybe more of your time better spent on your second
Yes.
and third issue.
Judge, if I, just briefly to go back to that issue, I know you've
Now you
warned
go
me.
back to it, but I mean, you had limited time to argue, and I think you started out by saying that your other two had a little bit more meat on it.
Very well, Judge, I'll move on, and if I have a minute afterwards, I'll come back. The second argument goes to the issue of the appointment of this special perjury counsel at the behest, it seems to me, of the prosecutor. I haven't found too many cases, or any cases, and neither did the prosecution, supporting this kind of appointment because they were concerned that she may commit perjury.
Well, do you take issue with the fact that the DA has an obligation to warn a potential juror of perjury charges? You take issue with that statement?
Only if it becomes a warning that becomes a theme throughout the testimony. A warning before you testify, perhaps, but he kept through her testimony.
So they need to wait until after the witness perjures themselves?
But that's not really his call. His job,
But
if
the
there's
flip
a...
side is that if he's prepping the witness and puts the witness on and
Yeah.
thinks the witness is going to do that, there's going to be a claim of intimidation. So of course he has to bring in someone who's not going to be in that position, whose interest is going to be the witnesses.
First of all, I don't think under this record, he prepped her. He tried to prep her. Second of all, she was the only potentially...
Well, first, let's go back to the witness. There was counsel appointed, and there were times when that witness asked to speak to that attorney during testimony, before she continued on.
I don't believe that that's the facts of this case. I think some of the behesting was done, well, it was done at the behest of the
Did she
DA.
refuse the assignment of counsel?
No, but...
And doesn't she have the right to have her own rights protected by the court?
Yes, let's assume that's all correct. The problem, however, is a perception. The judge placed the attorney right next to the witness.
And unfortunately, that wasn't preserved.
It certainly, he says it so in the record.
I understand, but did you, preservation means the other side stands up and says, objection, Your Honor, I would like counsel not to stand there.
But he objected to the appointment repeatedly.
Yeah, the appointment and placement of the attorney, I find, well, I don't find it that way. It's not split. We don't split here. We're talking about the fact is, he appointed somebody and he placed them in a situation. We've seen many of records, this panel here, even in civil cases, where authorities asked the counsel not to stand close during questioning. There's been an objection as to the conduct, but there's no objection here as to the placement, physical placement of Mr. Jeske.
But Judge, I think that's just sort of speak a lesser included offense. If you object to the appointment of somebody, then the whole scenario is objected to. You don't have to separate out each single component.
I'm not so sure I agree that the preservation of jurisprudence in this state is that when you make an objection that it carries throughout. But we'll take a look at that issue.
Okay. And lastly, Your Honor, is the notion that the judge himself relied, I guess, on his own memory or notes, found that there was no evidence of innocent explanation, and therefore initially...
What evidence of innocent explanation was before the court prior to your client testifying?
But that's not the...
What's in the record that there was?
But that's not up to the judge. There's a presumption of innocence. Remember, in this...
There certainly is a presumption of innocence, but in order for a charge to be appropriate, there must be something in the record to cause for same. The court did ultimately give that charge, correct?
That's correct.
And your claim is it forced your client to testify.
That's right, because he had no other alternative. Remember.
Well, your client said that the drugs that he took, he got them from the victim. The victim testified. If that were so, he could have inquired of her on cross-examination and not have taken the stand if he chose not to do so.
But the difference between this jury charge and other jury charges is that it goes right to the presumption of innocence, because now an inference is created that the mens rea element of the crime has been established.
The court gave the charge.
Oh, after.
Forced him to the stand. Isn't your argument, or shouldn't your argument be, that the innocent explanation instruction is part of the consciousness of guilt charge?
I did argue that in the
Right.
papers. Yes.
Right, so the DA asked for consciousness of guilt. Within that charge is the language that you wanted in there about innocent explanation, that if you fail to take the breathalyzer, it can be held against you unless the defendant had an innocent explanation for failing to take it. It's all one charge. They're not separate charges, right?
That's correct. It's
So
within the same.
yeah, if they asked for the consciousness of guilt charge, which the DA did, you can't give half the charge.
That was it,
That's your
essentially
argument.
my argument in the papers, because as the charge itself says, common experience teaches that even an innocent person who finds himself or herself under suspicion may resort to conduct which gives the appearance
Right,
of guilt.
so it was-
It's to ameliorate the harshness
Right.
of the inference.
It was not your request for a charge, it was theirs. They
That's
got the
correct.
charge and the court gave half of it.
That's correct.
And the argument is, well, your client, there was no evidence of innocent explanation, thereby shifting the burden to your client. He hadn't even testified yet.
That's correct.
And to get the charge, he had to give up his right to remain silent. To get the half of the charge that they wanted, he had to give up his right to testify. That's really what you're arguing.
Yes, and that came after defense counsel asked for a brief adjournment to appeal that issue to this court, which was denied, so he had no choice but to put the defendant on the stand. Your Honor, if I may just hark back to the very first argument for 15 seconds, I think it's
You got
important.
15 seconds, I'm looking
Yeah,
at the clock.
The prosecutor said we were not offering the testimony of the 911 operator for the truth of the matter asserted. If that's the case, and that's in the record, that is the sine qua non, that is the heart of the hearsay exceptions. And since he said we weren't offering the statements for the truth of the matter asserted, there were no hearsay exceptions. That testimony should not have been allowed in at all.
Thank you.
Thank you.
Good morning again, Your Honors.
Good morning.
I'll address the 911 operator's testimony briefly. I think that we can admit that the prosecutor was perhaps a little bit muddled in terms of his argument with why the 911 operator's testimony should have been admitted. However,
Well, wait a minute, how's that muddled? He says, I'm not offering it for the truth.
well,
If it's not offering it for the truth, then we don't get to present sense expression, we don't get to the exception for excited utterance.
Correct, and I think he provided the court some different options. That even if you want to consider it could be hearsay, it's still an exception based on present sense impression or excited utterance. But I think it's pretty clear his intent overall was not to introduce it for the truth of the matter. So I think counsel's argument that the prosecutor was sort of confusing what portion of the statement was hearsay or who was making the hearsay statement is somewhat unavailing, because I think the prosecutor was just simply offering some alternatives for the court to consider, all of which would have allowed the testimony to properly be admitted, which it was. I would submit that it was not not a hearsay statement because it was not offered for the truth. But even if we consider it under the excited utterance or present sense impression rubric, it would still be admitted under either of those.
How about I'm curious about the innocent explanation language of the consciousness of guilt charge.
Sure.
Have you ever seen a case in your research or your practice where court gave half of the consciousness of guilt charge, the one that's favorable to the people, and left out the other half that's favorable to the defense?
Not that I was able to find.
Nor have
certainly.
I.
I would point the court to the language of the charge itself. Now, in the transcript, it's 4 or 5 paragraphs worth of jury charge. The paragraph in question, and it is one single paragraph of that section of the charge, that paragraph standing alone, I don't think would turn this case one way or the other. The rest of the language still contains a cautionary instruction that consciousness of guilt, standing alone is not enough to convict. It is something the jury can consider but does not have to.
Would the error be harmless, though? Because there's no cases on point that support what you're saying. Nowhere in the history of the common law. But maybe it's harmless in that his innocent explanation that we found out from him was anything but innocent. He said he didn't take the test because after he was driving, and there was evidence that he had been drinking heavily, and he passed out. Well, he took Xanax, and he thought that might show up, and that, to me, is an innocent explanation for failing to take a breath test for alcohol.
Sure, and
so could we say that it's innocent even though he was, in their theory, he was forced to take the stand when he shouldn't have had to?
I think it is certainly harmless error in light of the bulk of the testimony. Even taking his testimony out of the picture entirely, you had the testimony of the victim, you had the testimony of, I believe it was 2 deputies who responded, who corroborated the victim's testimony, but also were able to provide the more damning testimony in terms of the field sobriety test and the like. It is certainly harmless error, but in any case, the instruction, as the court had sort of originally proposed, still, I think, contained adequate cautionary language, given the fact that there's no strict requirement that the court instruct the jury with particular language. It is the trial court's discretion to instruct the jury appropriately, and I think the court made a valid observation that we don't want to say something that would cause the jury to thereafter speculate about defenses. So I think that the instruction was proper. Briefly, with regard to the assignment of counsel, the vast majority of the discussion, if I'm not mistaken, about the assignment of counsel occurred outside the presence of the witness herself. So I struggle to see how it could have been sort of an intimidation or a threat to appoint this counsel.
The court was taking cautionary steps.
I think so. If there's any other questions, I'll...
Thank you.
Thanks.
524, People v. Bello. Good morning, Counselor.
Morning. May it please the court, Nick DeFonso appearing for Gabrielle Ballo. Honors, the Second Department has observed that the power to grant resubmission should be exercised sparingly and discriminately. Our first argument here is that the resubmission motion should never have been granted. And of course, we've never had full access to the grand jury transcripts or any access to the resubmission motion, so we do rely on this court to do its own analysis of those documents.
Well, really what we have here is, as you point out, there should have been an analysis between whether or not anything was new compared to the first presentation to the second presentation.
Yes, that's in addition to what I'm asking you to do, which is to review the motion court. So those are two separate things, but yes, that was not done and it was requested.
But it really boils down when we get to the issue is that what the court has before it, correct?
What this court has before it?
No, what the court below had before it. How can the court make a determination of what it had before it if it didn't have everything before it?
You're talking about the, I'm sorry, are you talking about the motion court or the trial court?
Well, ultimately, the trial court, there was an application made to represent to the motion court.
Yes.
Correct? And then ultimately, it went to trial, and the trial court had to make an ultimate determination on when the motion was made.
Yes, it did. And it determined that the resubmission motion was appropriate, but it didn't expressly compare the grand jury transcripts, and that's why...
Didn't make a ruling. It had been requested, and certainly there was no ruling in the record that was done.
I think I understand what you're saying.
You requested it, and we don't have it.
Right. There's no ruling in it. So
they say we could. They recognize the court didn't compare the original grand jury minutes to the second grand jury minutes to determine whether, in fact, new evidence was submitted. And that's clear. I think he would concede that when he gets up. He's just merely arguing, well, we have the 2 sets of grand jury minutes, and we can do that ourselves. What do you say to that?
Well, this is the La Fontaine Concepcion issue, and I would say that that's not part of a multi-pronged test.
So all we could do is basically, if you're correct, we get, is remit for a court to make a determination.
I think that you're compelled to do that. I think you're legislatively restricted.
We recognize our limitation.
Oh, okay. Well, I suppose with respect to, I'll move on to the second argument.
The Singer argument?
The Singer argument, yes, and that is that the defense was entitled to a Singer hearing because there were issues of fact regarding two Taranovich factors, the reason for the delay and the prejudice to the defendant. And I'd like just to make 2 points with respect to prejudice first and then move on to the reason for the delay. And the first point is that the prejudice factor encompasses both specific prejudice to the ability to to respond to the people's charge, and it also encompasses prejudice to the individual defendant.
And it's the latter that is your real argument.
Certainly, the latter in this case was at its maximum. It was alleged by the defense throughout the proceedings below that the defendant was publicly vilified throughout this time period, and it was disputed by the people by failing to acknowledge it.
But your client was out of custody. Right. She was charged with a fatality, leaving the scene of the accident. The grand jury no-billed it. It sounds like they initially are going to vote to indict, and the DA comes in and instructs them not to. And then they wait a while. The DA retires or goes to Supreme Court, and there's an acting DA. That DA pledges in his campaign he's going to bring justice to this case, so he resubmits. But your client's out of custody that whole time. And so you're saying she would have been better off if they move for the second grand jury sooner? Instead of being prejudiced by the delay, she was out of jail longer. Memories fade. How does she not benefit from that delay?
Well, incarceration is a separate factor from prejudice. I recognize that they are related, but they are separate. And so we do recognize that the incarceration factor weighs in favor of the people. But technically speaking, yes, a pre-indictment delay is mollified if you seek to resubmit the charges as soon as possible. And
well, they came forward with proof that as soon as they found out the person changed their testimony, they came forward with that, didn't they? Isn't, from my read of record, correct me, because you seem to be confused with my questions, is that when the witness changed their testimony, they didn't wait 2 years to bring that to the grand jury. That was one of the key witnesses and she admitted that she lied previously. Isn't that correct?
well, no, I would
Okay.
push back on that.
Okay, go ahead.
Well, they said, they represented during an oral argument that they were aware of the perjury when it happened. So and then they made no representations at all as to what steps that they took to try and change that witness's testimony or secure that witness's cooperation.
Didn't they say that there was repeated contact with investigators in that witness?
They represented that at oral argument for the order to show cause, but they never asserted that in their response to the omnibus motion. And essentially they simply claimed that the delay was because of trouble securing witness cooperation, but they never identified the witness.
Right.
They never explained why.
Well, look, they got witness cooperation. The way they got it was they charged her with a crime, hindering prosecution. They knew she lied, as you said. It's obvious they knew she lied right out of the gate. And I guess your argument is that it wasn't until the acting DA took office that they took that step of charging her with hindering prosecution by lying. And there's no reason why DA Sedita couldn't have done that immediately. Is that a fair summary of what you're arguing here?
Yes, that's the due diligence component here, is that there's no assertions that they complied with their due diligence obligation. There's no summary of a sort of timeline of the investigation. There's no record.
And based upon all those factors, a hearing would have obviously borne out what steps they took, if any, to correct this issue. Without the factual hearing, there's no way the court could have made a determination.
Certainly, it's the reason for the delay was a critical factor for the Taranovich analysis. It's not the case, what they argued below, that if they were to lose this on that factor, that they would win overall anyway. It's well within the time frame of delays that have been reversed for failing to have a good cause for the delay. And the final issue of fact is that the defense alleged that this was less about witness cooperation and more about political opportunism. And winning on that issue would certainly have resulted in a win for the
Fair enough.
defense.
Thank you. Good morning.
Morning, Your Honors. David Harry for the people.
Why isn't he entitled to a hearing?
On the Singer motion, Your Honor, he's not entitled to a hearing because the motion can be resolved on the papers. There's no issues of fact that need to be resolved in order to determine the motion. The defense is arguing that the reason for the delay and the prejudice to the defense are the things that need to be set forth, or need to be explored at a hearing. But he failed to adequately even allege any prejudice. This argument about her being vilified, I don't even understand how that, I mean, that happened before the first grand jury presentation occurred, presumably. So I don't know whether it matters whether she's charged in 2014 or 2016. If anything, she got a windfall from the result of the first grand jury, and now on appeal she's trying to get a second windfall by getting the whole case dismissed.
So what you're saying is that there was no claim that she was prejudiced in her ability to defend?
Exactly. Yeah, there was no claim that we, dragged this out for witnesses, for the defense to disappear or anything like that. So
Most speedy, I mean, we have speedy trial rules, and legislature just passed these more strict ones.
yes, they did.
Most of the defendants don't want a speedy trial.
Right.
Now, if they're in custody, it's different. But if you're out, a speedy, a delayed trial helps the defendant in most cases, right?
A delayed trial, absolutely. Yes. I mean, as they say, justice delayed is often justice denied. Maybe not in this case, but yeah, exactly. If the defendant was in custody for 2 or 2.5 years, we'd have a much bigger problem here. But there's no prejudice to the defense. The reason for the delay doesn't need to be developed anymore. I mean, as Your Honors discussed with my opponent, we had the new evidence, which you, I'm sure, have reviewed and will review again if necessary from the grand jury minutes. And even if the argument is that there were other reasons for the representment for taking a second shot at this, those are legitimate reasons. It's a different person in charge of the DA's office who wants to take a different tack. If they want to correct what happened in the past, these are all legitimate reasons for representment. This isn't forum shopping, which goes more to point one. This isn't trying to drag out the prosecution to prejudice the defense. And so there's no need for a hearing on the Singer motion. And for the point one, I don't think there is.
Counsel raised it with point one. You do recognize that we do run into a potential Concepcion problem.
I don't agree that it's a Concepcion problem, Your Honor. I agree that there was no express ruling on that particular aspect of the motion. Of course, you did have a situation where you have Supreme Court trial division reviewing potentially the judgment of the lateral court, essentially, another Supreme Court.
You're asking us to make a decision that the court didn't make.
Well, I'm asking you to review I think this court should review the decision of the order of the judge, Justice Wolfgang, who granted the first motion. I think that's appropriate. Justice Burns was, again, it's a lateral court. I think it was appropriate for him not to make an express ruling. And again, I don't think that was a standalone motion. It was one argument in support of a motion to dismiss. I think this court can look at our affidavit, or application rather, review the minutes of the 2 grand juries and make that decision. I think remittal is not necessary in this case.
Thank you.
Thank you, Your Honors.
525 People v. Graham. Good morning.
Good morning. May it please the court, Brittany Clark for Isaiah Graham. First, the trial court abused its discretion as a matter of law in entering into evidence 2 photographs discovered on Mr. Graham's cell phone. First, I want to focus on People's Exhibit number 66, which is the photograph of the bare hand holding the Colt revolver. First, with respect to number 66, the people failed to establish that Mr. Graham was the perpetrator of the uncharged crime by clear and convincing evidence. Here, the detective testified that he found the Colt revolver in a multimedia message sent to another individual. There was no evidence that the picture itself was taken by the phone or that it was even saved in the photo gallery of the phone itself. And then on top of that, there's no distinguishing marks of the hand or of the background to say that this is something that Mr. Graham specifically possessed prior. And then on top of that, second, while identity was at issue for the November 18th shooting, there's nothing unique and specific about a Colt revolver in general as to satisfy the modus operandi requirement to make this admissible.
Well, can I just make sure I understand the facts? It is a big record, and you know better than I do, but he's found allegedly on November 25th of 14. He's alleged to have possessed this Colt revolver.
Yes.
It was next to another gun that had his DNA on it. And so he's charged with possessing a Colt revolver on the 25th.
One clarification, there's no evidence that this Colt revolver found on November 24th is the exact Colt revolver.
I understand, but he's charged with separate charge, not the murder, but he's charged with possessing that Colt revolver, right? From the 25th?
Correct.
Okay, so he has a crime with revolving the Colt reporter, the Colt revolver. On the 17th, 8 days before, there's on his phone, if I'm not mistaken, there's a picture of a Colt revolver that looks identical to the one he's charged with possessing, right? On his own phone.
Yes, that's 7 days prior.
Right.
And it's sent in a multimedia message. It's not saved on the hard drive of his phone. It's not saved in the gallery.
Right.
It's sent in a multimedia
So,
message.
and you would acknowledge that the gun on his phone looked identical to the one that was found that he's charged with possessing?
There was no testimony at trial that stated that fact.
Okay.
They said it was the same type of weapon, but there's nothing to
All
say that this exact gun is the exact gun found 8 days later on
Looked
a different
like it.
time and
Looked
place.
like it, no unique characteristic.
Right,
Says
exactly.
it's it.
There's nothing unique.
So how is that not relevant? He's charged with possessing a gun on the 25th, and then lo and behold, he's got an identical-looking gun on his phone, a photograph, 8 days earlier. Isn't it directly relevant to that charge alone, if not the murder?
Well, with respect to the November 25th shots fired incident, identity was not at issue with that crime, only possession. There's identity at issue with November 18th, but he's charged with possession. The only issue with respect to possession on November 25th was the idea of constructive possession, that he was walking around a garage and then the item was found behind the garage. There's no identity issue. They apprehend him close to the scene. Police are following and chasing him and his friends. There's nothing to say that at first, the first step in Molyneux is that identity has to be at issue. And with that specific crime, it's not. And moving on.
But the court did give a curative instruction, didn't they, on that issue?
I believe the court gave a curative instruction during its jury charge. I can't remember right now if it gave it while the evidence was admitted. Secondly, with People's Exhibit number 67, which is a photograph of Mr. Graham holding a semi-automatic weapon with a blue glove. First, that weapon was never alleged to have been the murder weapon.
He was charged with possessing it on the 25th, though.
Yes, and again, back to my point, though, the issue, though, is that identity is only at issue with the November 18th incident. To say that Mr. Graham was possessing a weapon on a different date at a different time, the issue there is constructive possession. There's nothing about a photograph of Mr. Graham holding a semi-automatic on a different date at a different time would help the jury identify him in a blurry surveillance video.
But isn't it just relevant evidence and not Molyneux evidence? You keep talking about identity. I assume you're saying that it was offered to establish his identity, as a Molyneux, Molyneux evidence. But isn't it just relevant evidence on the crime? And not Molyneux evidence?
I'm not sure exactly. But even if it was, assuming that's correct, I think that this evidence is more prejudicial than it is probative, and it would fall back on the second prong to say that there's nothing necessarily connecting the two events, and then.
Well, I think where the problem arises here is, and there's no dispute with the following facts, that the individual who shot the victim Okay, there was no casings found, which is consistent with a gun that doesn't discharge one.
Right.
And there's no dispute that the person who shot the victim went back after he shot him and took the victim's gun.
Correct.
So there's two guns. There's no dispute that the DNA was found on the 380 semi-automatic of the defendant and the blue glove, where obviously it was found there. And so the tying the cases together, there was also a sweatshirt, correct?
Correct.
That had some white saying, some saying on it.
Correct.
And that was also found, wasn't it?
Yes, it was found,
On the 25th, was it?
no, it was found, I believe prior in the area when the police surveillanced the area
Yeah.
after the shooting, it was found there.
Well, it was found next to a hat that had your client's DNA on it.
Correct, yes, it
And there was
was.
no DNA from, they couldn't get any DNA off the sweatshirt, but
Multiple
it was
contributors.
next to a hat that indisputably had his DNA on it. And they had multiple witnesses who testified that he was wearing that sweatshirt with that writing, and then they had a video of him walking in McDonald's where he worked, wearing an identical shirt with the identical language.
Correct, but if you have watched the surveillance video and were relevant to the testimony at trial, by all accounts, the video in itself is blurry. There's no
Well, I give you credit with
distinguishing.
that. I've watched numerous.
Yeah.
And you can see it. Really, I really couldn't tell, quite
No.
frankly. But I think where the problem arises here is that it was clear, well, we have the co-defendant testifying who shot him. We have the situation where it appears that the person with the writing on the sweatshirt, his hand was still up when the victim fell, and everybody else ran. So it appears to me that whoever had the sweatshirt on at the time was the perpetrator. And I think that as we start to build a circumstantial, coupled with the fact of the co-defendant's testimony, and then also the text messages, as you well recognize, that were recovered afterwards about him sending text messages to certain individuals, that's obviously you raised later on with, interpreted by the police investigator.
Yes. Just to go back to Justice Peridotto's question, I think the reason that this is characterized as malevolence is specific is because it's classic propensity evidence. It's classic evidence of gang violence and of a possession of a weapon. The jury's going to assume that Mr. Graham,
Why isn't it relevant to the crime?
What was that?
Why isn't it relevant to the crime?
Why is it irrelevant?
Why is it relevant to the crime?
I would maintain that it's not, that it was on a separate date, on a separate time.
Okay.
I
I see. Your argument is that well, it could be. It's maybe relevant to the 25th of the possession of the weapons.
Correct.
But it's irrelevant to the to the shooting that took place earlier. And that's when I asked you earlier that was there a curative instruction. My review of it, in there was some curative instructions given, which kind of separated the two, that this should be used strictly for the possession on the 25th and not for the purposes of the, so they were charged with that.
Exactly. And then the last point I would like to focus on today is the issue with the consecutive sentence in this case. I maintain that the trial court improperly ordered the sentences under count 3 to run consecutive count 1 and 2, mainly because...
You recognize that under certain circumstances, they can be consecutive.
They can be. That's what People v. Brown states. But in this case specifically, the people charged Mr. Graham with these 3 counts as one single transaction, as one act. That's how it's charged in the Bill of Particulars. That's how it's charged to the jury at trial, and that's what they found him guilty of. And then only subsequently, after the fact, try to say that because circumstantially he was on this walk and then pulled out a weapon, he must have had it possessed before.
Well, there's proof in the record that when he left the house, they were looking for an unnamed individual who threw a rock at his friend's sister.
Correct.
They don't even know who they have
They have no idea
who the person is.
Right.
And there's no dispute from at least the video, and I watched them from street to street to street. They were walking together. There's no dispute. The 3 of them were walking together. Then the 4 of them were walking together, and then some individual pulled out a gun and shot him. So it can't be inferred from that there's a separate, he possessed it. There's no intent to use it to kill somebody when he left the house, and then at the time of the shooting, you can infer the intent.
I would agree that you could infer intent under those circumstances, but I think what is distinguishable here is that the people charged it as a single commission and transaction. The defendant is entitled to be aware of the charges against him and to be put on notice so that he can prepare his defense at trial. And here specifically, the people stated in the bill of particulars, and then again later when the jury charge was given, that it occurred at a specific place at a very specific time. And I think under those circumstances, it precludes them from seeking a consecutive sentence.
Thank you, Counsel. Good morning.
Good morning, Your Honors. May it please the Court, Ken Tyler for the people. I think the panel is well aware of our position with respect to the Molyneux evidence. Just to briefly address a couple things. First, Justice Central, I believe it's correct that the court gave a curative instruction right before, during the presentation of that evidence. It wasn't at the end of trial. With respect to the proposition of where did the photo come from, I believe there was testimony that the photo was actually taken using defendant's phone. I believe they read the data when they did the phone dump and were able to determine that. I believe either Justice Lindley or Justice Central, you pointed out that in addition to the timing, with respect to how those photographs were relevant to the crimes charged, they were paired with text messages that were sent on the same day, 24 hours before the shooting. Can 9s go into a .38 special? A .38 special is a revolver. Defendant is asking about the compatibility of a particular bullet type and use of that gun 24 hours before the victim is killed. To briefly address Justice Peridotto's point, I think it's arguable that this is just relevant evidence of crimes charged for those two particular dates. I mean, they both go to, he's charged with possessing guns on one date and using a gun to shoot the victim on another day. I think it's all relevant evidence.
But couldn't it be Molyneux and relevant evidence? Could be
sure.
Both. And that's what it appears. But to be admissible just has to satisfy one. And you think it's relevant to his possession of the weapons on the 25th, that he had photographs of it seems to be exact weapons that he was charged with possessing.
Absolutely.
And is it relevant that he had him on his phone before he charged? Well, it's not dispositive, but certainly doesn't hurt him, or certainly doesn't help him any.
No, and that's right. And of course, the court analyzed it as a Molyneux issue, and the people proffered multiple bases for why that was an exception to Molyneux. Not just the identity issue, which I acknowledge the county court judge is the one that he latched onto, but the people offered it as inextricably intertwined to the narrative, completing the narrative. And so there were other reasons why that evidence is relevant. And as you'll see from our brief, we argue just the temporal, the physical, the logical proximity of all that evidence is what made it more probative than prejudicial. If there's any other questions, we'll rely on our brief. Thanks.
526, People v. Robinson.
Good morning, Your Honors.
Morning, Counsel.
May it please the court. I'm going to focus on point 1 of the brief, and it's apparent from the Huntley hearing testimony that the Fire Marshal McKinney obtained the name of appellant through her estranged boyfriend, Derek Williams, as a person of interest. He also obtained her name from 3 neighbors, or 3 people in the neighborhood as a person of interest. He also testified that both the Buffalo Police Department and the Fire Department were focusing on appellant. They were both trying to interview her, and they were both cooperating, exchanging information. She was definitely
So they left her a note on her door, and she went in to speak voluntarily. I think your argument, or as I read it in your brief, is that she was almost made too comfortable, and so that makes it a custodial interrogation?
I find
or
it
at least makes it a custodial setting.
Yeah, I find it troubling that she viewed this as somewhat relaxed, or they made it seem so relaxing and comfortable for her. And McKinney testified that he knows he acts under official authority, under color of law, knows this is a law enforcement investigation. She is completely unaware of this, that she really is the main suspect here. This is a veiled interrogation.
Right,
what
but
happened
doesn't
here.
that, I mean, counsel makes a legitimate point in his brief that the fact that your client had no idea that she was a suspect, that she was relaxed, they made her think that this was just routine questioning, that undercuts your argument that she was in custody. She takes a bus there. She's in the kitchen of the fire department, not the police department. She's in the kitchen at the fire department. if, I think you had a better argument for custody, because again, for custody, it's what an innocent person, a
Correct.
reasonable person, innocent of any crime would have thought, whether they were free to leave. Your client, according to you, was led to believe, oh, this was routine, she's not a suspect. They misled her into thinking that this wasn't a big deal. Well, that would augur in favor of a finding that innocent person in her position
Correct.
felt that she could have left.
That it was non-custodial, but
Not custodial.
correct, and that's what I find troubling about this. This was made to seem like it was. Who knows where this fire department was? Who knows where the interview were? Yeah, of course, I argued that it was such a relaxed and comfortable atmosphere, but McKinney knows that she was the main suspect. She was the main suspect.
But it's not the
here.
subjective beliefs of the police officer. It's
Correct.
an objective standard. And it's not what your client thought. It's not what the police officer thought. It's what an innocent person, reasonable person in your client's position would have thought.
I understand that. McKinney, the fire marshals, knew that this interview process, it went from investigatory to accusatory very quickly. They
Well,
knew.
I don't disagree with that. As soon as they asked her, did you set the fire?
Correct.
That's an accusatory question. After she responded, then they immediately give her Miranda. So really, the question is whether this was a custodial setting or not.
Correct.
That's the
And
question
whether
for
she
us.
felt it was custodial or not. And I understand the circumstances
Yeah.
here. And it's very troubling that she had no idea that this was going to be a law enforcement investigation or interview. And I believe this was just a veiled interrogation made to elicit incriminating responses for her. McKinney knew that this was a law enforcement investigation, knew that the Buffalo police, everybody was looking for her. And unfortunately, she was led to believe this was kind of like a non-custodial, and I understand the complications here.
Right.
But this was designed to prompt her to elicit incriminating information.
Thank you, Counsel.
Thank you.
Morning.
Good morning. May it please the court. Michael Hillary for the people. Just to echo Justice Lindley's point, yes, this was a cordial atmosphere. It was intended to be comfortable for the defendant. It was made so. If we are going to throw out confessions because the atmosphere has been made too comfortable, then we lose them all.
Thank you. 525, People v. Abigail H.
Morning, Your Honor. I'd like to introduce Rebecca Const from our office, a new associate who will be arguing this appeal. For one thing, I don't think our client was convicted of a crime called the People v.
Okay.
It pleases the court, Rebecca
I'll have
Const.
to watch the video back. That is joke, so. Go ahead.
If it pleases the court, Rebecca Const for Daniel Darby. The big issue that I want to focus on in this case is the fact that his admission was not knowingly given. When the court was asking him whether or not he understood whether this was voluntary and was a termination of parental rights, his response was sort of. And when pressed a little bit further that he understood that this was a termination proceeding, he was sort of like, yeah, I guess. And then the court finally had to press him and be like, we need more of an answer than that. And that's when he finally said yes. And that's when the judge was like, okay, I'll accept that as knowing and voluntary. There was no more interaction with the court, to say you really understand what you're doing. And at the first dispositional...
Did he ever move to vacate the finding of permanent neglect?
From what I see in the record, it wasn't. They sort of moved forward, and in the dispositional hearing, he again stated, he specifically stated that he felt that he was being forced to sign, that he wasn't given a choice. If he didn't sign, he would lose all of his rights. He'd have no contact with his children.
That was multiple months later, though.
It was because there was proceeding.
How do you bootstrap it from October back to July?
Well, when he had, you've seen the record, he had a lot of health issues. There were a lot of reasons why things were delayed longer and longer.
The other thing is, in July, the whole purpose of July was to give him an opportunity to still have reunification. So, and that changed by October, so.
It did, but like I said, there were extenuating circumstances. He had the issue with his eye, he's got these back problems. They had the ER records of him having fallen. He had been
making attempts to go and see his children during that time. He had made a few attempts to go and do the services, but because of his health issues, he really had problems getting there. The visitation with his children, I mean, he's in Syracuse, they're in Seneca Falls. It's a long travel time. He had to take buses.
Well, that's part of the story. The other part of the story, though, is that they attempted to get him transportation multiple times, and you know, he says, I bring it to my doctor, and then he doesn't follow up on it when he doesn't get it back, and months go by, and months go by.
And he made attempts to have friends bring him, but all the visitation, because that county didn't have the same system that we have in Syracuse, he couldn't do weekend visitations, so the travel issue, it continued to be an issue for him.
He was late all the time. Look, and I'm sympathetic. Having your children taken from you is probably worse than being incarcerated. So we don't take these cases lightly. But your client was given a break. He was about to go to trial and probably lose, and then lose his children. But they said, okay, if you enter admission, we'll delay the case a little bit. If you cooperate so your children get involved in services, then you may be able to get your children back. Then the next court date, a month later, he doesn't even show up, right? That was from July, he made the admission, August. A month later, he doesn't even show up. And then he makes the visitations. I think he made 2 out of 5 or 6. And you would think if your children are on the line, you call up and say, I missed the bus, something. He doesn't engage in the service. It's sad, but he had plenty of opportunities to help himself, and he didn't.
He made efforts. I mean, if you look at the record, efforts were made. Was he perfect at following through? I mean, he said he went to some of the visits. He missed one. He was late. The busing, he kept being late for things. He wasn't giving any dispensation for his back issues when at the visitation center. There were extenuating circumstances.
The case is troubling, but as you know, we got to get past the knowing and voluntary, and if we do, looking at whether or not it's been a motion, has been mentioned, to withdraw or vacate, then we get to the underlying determination. So we'll look at all those issues.
Thank you.
Thank you, Counsel. Good morning.
Good morning. May it please the court, Courtney Reddick on behalf of the children. There was just a lot of discussion about these efforts that he made, or half-hearted efforts. That goes to whether the dispositional order was appropriate. That's not even appealed from or argued in the appellant's brief. They're not saying that the actual termination of the parental rights or the no contact was an error. It's going back to the admission itself. So this gentleman, if we can use that word, throughout the reading of the record, he was combative. He missed court appearances. When it came down to the termination of parental rights, and he knew the contact with the children was on the line, and he asked for his trial, and he had his trial on that issue. To go back and say 4 months earlier that I didn't understand the proceedings is disingenuous. There was specific reference to waiving his right to appeal, and he knowingly admitted that. He understood he was waiving his right to appeal, and here we are. But let's focus on the children here. These children have been in foster care nearly their whole life. There was a brief period of time when the father had them, and that was after their birth a couple of years later, and they're still in foster care. By way of an update for the court, the mother has passed away since these initial proceedings, and the children were removed from the foster home that they were in due to some allegations of abuse against the children there. They are in another pre-adoptive home, which is also a family placement. But from all reports from other people involved in the case, they're doing well. They need some permanency, and I don't believe the father has made a case here to show.
The house, the foster home that they were in, time of trial, that everyone was talking about what a loving foster parents they are, and we got to feed them up for adoption. They were being abused there.
Apparently, one of the children of the foster parent assaulted one of the girls. So it wasn't the parents that had, or the foster parents that engaged in the conduct, it was the foster parent's biological child.
Sounds like they might have been better off with the father, but that's...
I don't know if I'd go that far, Your Honor, because he is not apparently involved in the new proceedings that are in family court. And I know the appellant didn't address the issue of the judiciary law. I would just say that That's not preserved, and there is a
We've
meeting.
had that issue up here a number of times.
And I've seen that on some other cases, and I hope the court doesn't open Pandora's box. This is not the case to open the box on. Thank you.
Thank you, thank you. 530, 531, matter of Lennox M. in Lyle M. Good morning.
Thank you, Your Honors. May it please the court. My name is Amy Keller. I'm here on behalf of Steuben County Department of Social Services.
And the appellant has
The
submitted.
petitioner respondent, yes.
Excuse me.
My understanding is that the respondent appellant's counsel did submit today, but I am prepared to argue my brief and take any questions from Your Honors. As you are aware, this case involves two young boys who at the time of the order of disposition were 4 and 3 years old. The 3-year-old had spent his entire life in foster care, as his mother was incarcerated at the time he was born.
Counsel, we're familiar with the record. We're really looking to whether or not they the requisite requirement by DSS and before incarceration, during incarceration, and so we're familiar with all that.
Thank you, Your Honor. In regards to whether the department made its diligent efforts burden of clear and convincing evidence while she was not incarcerated, that is a very brief period of time from December of 2012 through the beginning of August of 2013. During that period of the time, the Department of Social Services bent over backwards for Miss Murphy Sears. We provided her mental health treatment referrals,
Right, and
substance abuse.
This is all in your brief, and I, for one, have no questions on that.
Okay. Thank you, Your Honors. Then I will rest on my papers.
May it please the court. My name is Chris Redfield, and I represent Lyle and Lennox. The children were quite young when this disposition was done. November 16th, 2016 is when Judge Fafuri made her decision to terminate the parental rights of this mother. That is a long time in a 5.5-year-old's life. And as counsel said, Lennox, the youngest, has been in foster care the entire time. And, you know, we often refer to they're in this legal limbo. We're trying to get permanency. Permanency is very
Counsel,
important.
listen, we recognize the dilemma there, and we recognize the permanency aspect of it. So, I mean, you know, the end of the day is whether or not, whatever your goal may be, it may be great, but the fact of the matter is we have to determine whether or not the court made the proper determination down below. And if the court did, then hopefully they can have some resolution to their situation.
I completely agree, and I addressed it in the brief, which is why I'm not going to go through the evidentiary part of it. You know, the decision was what it was. But with respect to these children, I'm in the unique position that I've met these children. I've met the dog. They are doing beautifully. They have been in a long-term placement. It's a pre-adoptive home. Their issues that they had early on in life have resolved because of the services provided by the department. That's all in the record. They are doing well. And so that is primarily the reason why I believe that the decision stands. I believe it was well supported by the record.
You ask us to affirm the decision.
I'm sorry?
And you're asking us to affirm.
Absolutely.
Thank you very much.
Thank you.
Thank you, Your Honor.
532, Martinez v. Skarov. Martinez v. Skarov.
Good morning.
Good morning.
I have little to add that's not already in my reply brief. There hasn't been a demonstration of abandonment, unfitness, persistent neglect. The grandparents in this case couldn't even establish DRL 72 grounds for seeking custody of these children.
I don't think that was
They weren't
the
even
basis
arguing
of
that.
their,
Right,
I don't
they
think
weren't.
that was the basis of the application.
Are there any questions?
I have no questions.
All right, thank you very much.
Good morning, Rebecca Talmadge for the petitioner respondents. Certainly the facts and circumstances in the argument are laid out in the briefs before the court. It's my position on behalf of my clients that the lower court did properly find that extraordinary circumstances existed in the present case based upon the aggregate decision-making of the mother that...
Well, it's an aggregate of factors. It's the decisions that she made, the kind of the poor decisions that she made, the inadequate housing, the, really kind of instability in her life.
Yes, Your Honor.
Which the court found had a negative impact on the child.
Yes, Your Honor, absolutely. The decisions that hit many factors, housing, employment, medical needs of the child,
right.
And exposure to the boyfriend,
right.
Later fiance, that each and every one of those decisions, and then further ability to make better decisions or different types of decisions moving forward. That the evidence, the mother's own...
She was pretty steadfast in her belief that this man was going to continue to be part of her life, continue to be part of her child's life, despite despite the fact that he was going to be incarcerated for quite some time, and had a history of domestic violence.
Yes, Your Honor, insistent upon it.
He was convicted for strangling a pregnant woman.
Yes, Your Honor.
And sentenced to a prolonged period of time in prison, and she believed him, it was fine. She wanted him to adopt the child.
Yes.
And they lived in a flea-infested hotel
That's
with
right.
no health insurance.
That's right.
Nothing. So you think that's extraordinary in your view?
Yes, I do, Your Honor.
All right.
Thank you.
Thank you.
Hey, please, the court, Wayne Broderick for attorney for the child. You already mentioned a lot of factors. I don't need to repeat them. I think the error in appellant's cases, that not including the S on circumstances, that's a basket of circumstances, is not one factor. Although I think some of the factors in and of themselves could be considered extraordinary. Certainly when you look at them together, they're extraordinary. I will report my client is still doing well. She's happy with her grandparents, and mom's not actually even exercising the contact that she has. So.
Thank you, Counsel.
Thanks.
Thank you. 533, 534, Mangowski v. DeMarco. Good morning.
Good morning. May it please the court. Elizabeth Hoffman, Costello, Cooney, and Fearon on behalf of the defendants, appellants in this action. This appeal primarily concerns the significant abuse of discretion by Supreme Court in granting a preliminary injunction in favor of the respondent, a 5% minority member of the appellant LLC.
And we're familiar. I think the really what it boils down on the injunctive relief is it's parceled out. We're dealing with the health and the car payments and the undertaking regarding that.
Correct. It is my client's position that the respondent failed to establish a likelihood of success on the merits. In particular...
Well, let me ask you a question. Do we even need to get there when we're dealing with whether or not the likelihood of success and those two issues when we're dealing with irreparable harm? It appears to be strictly a monetary issue, cost of health insurance. There's no exceptions why he could not get the same health and the car payment. So, I mean, doesn't that in and of itself could be dispositive?
Your Honor, you're absolutely correct. It's our position that the relief that was granted to the respondent by way of the injunction was something that could be compensated through monetary damages. There's a monetary value associated with his car as well as health insurance.
At least on these facts, I assume you would agree that in some circumstances the denial of health insurance benefits there might be irreparable harm, but on this record, it's your position that it is not.
That is correct. There is case law that states that if it's established that an individual could not obtain comparable health insurance, that could potentially constitute irreparable harm. But based on the papers submitted below, no such circumstances were ever established by the respondent.
He just says it's a financial problem. That's all.
Correct. And again, as Your Honor points out, that boils down to the issue of damages.
Right. If he has to go out and get a new policy, and it's more than the one he has, and he wins the case, he gets the difference in the cost. But let me ask you this one: if you win on the irreparable harm issue, and that there should have been no injunction. We vacate the injunction. Your secondary issue is with the undertaking, $500.
Absolutely.
Which is obviously preposterously low. Wouldn't cover 1 month of damages if the defendant wins. You'd be paying health insurance, cars and all that stuff. That was not even, but if we vacate the injunction, in the alternative, you want us to increase the bond undertaking. What do you want us to do with the second issue if you win on the first one? Can we increase a bond on an injunction that doesn't exist, in other words?
I believe that the case law would support the fact that my client would be entitled to the recovery under the bond, and certainly because the bond set for the original preliminary injunction was woefully inadequate, it would empower this court to increase the bond to an amount that would be satisfactory to recompense.
Because correct, I mean, your client's in a tough spot. If the defendant loses, the recovery is limited to $500.
Correct.
For all these monthly expenses that have been thrown out there. But how can we say to the plaintiff, we vacated your injunction, so there's no injunction anymore. Now we're going to order them to go out and get a bond for more money, $50,000 or whatever you're requesting, a bond on an injunction that doesn't exist. Who's going to give them that bond? And what would we do if they said we're not going to do it?
I see the dilemma that you're presenting. Unfortunately, the bond is the only way that my client can recover.
I don't agree with that analysis, your analysis, because you could have at that point asked for our review of the court. You could have came to an appellate division in term, asked for a stay of thing, saying that it's woefully inadequate.
Well, we
went back to the court, but not to us.
Correct, and the reason we didn't at that juncture was because the court, in the original granting of the preliminary injunction, never accepted any papers from either of the parties with regard to the value of the injunction.
Right, but that's why your client, there's another problem with this case, is that when the judge, it was Paris, I believe, correct? Ruled on the preliminary injunction, the defense lawyer said, well, I want a hearing. I'm entitled to a hearing on a preliminary injunction. Because what was given really wasn't a preliminary injunction. That seemed to be a temporary restraining order of some sort. Your client's lawyer demanded a hearing. The court said, I'll give you a hearing. Well, now we're a year and how many months later? Your client never apparently demanded a prompt hearing. And I know there was discovery and everything. The note of issue, I think, has been filed, correct?
No, it has not been filed.
It was supposed to be filed last week.
Correct, Your Honor.
So it's still, the plaintiff didn't file the note of issue?
The note of issue has not yet been filed. As the court is aware, there were some issues with regard to the briefing of this appeal. The briefing is not yet complete.
But that doesn't excuse them from failure to file the notice.
Understood. That's yet to be filed. And for the court's education, with regard to the hearing issue, we did ask for an immediate hearing with the court.
Right, but you never followed up on it. The court said we're going to have discovery first, which defeats the whole purpose of an immediate hearing.
Well,
that would be a hearing on the permanent injunction. But be that as it may, as Justice Sentra has indicated, you could have come to us for a stay. You could have come to us, say, even in the absence of a stay, could you increase that undertaking? Because if we win, we're going to be shorthanded a lot here. But you didn't do any of those things. You didn't ask for a hearing, and now the case isn't even ready for trial. In the meantime, your client's laying out a lot of cash every month.
Yeah, he is paying a lot of money every month. We have asked for a hearing, and because of the respondent's position that discovery needs to be complete, the court's permitted a significant number of depositions. I believe we've done roughly 12 depositions to date, with more to come.
Yeah. All right. Well,
so
there is case law that says that the issue on the bond becomes moot if the injunction is vacated. That if that case law is good, that leaves your client in a rough position if the defendant prevails.
Understood.
But on the flip side, if the plaintiff is successful in any of the fiduciary violations, there's an offset. So, okay. Thank you.
Thank you.
535 Barber v. Source.
Good morning, Your Honors. Matt Rittenauer for the appellant.
Counsel, before you start, I just got one procedural question to ask you, because I looking at the record. You requested a bill of particulars from the plaintiffs, correct?
Correct.
Okay, and it appears to be attached into this record as just the co-defendant's bill of particulars, if I read it correctly. Did this plaintiff here give you a separate bill of particulars, or was that one bill of particulars used for both parties?
There was one bill of particulars, I believe, that was used for both parties.
Okay.
Your Honor, on the issue of constructive notice, I think that the court below in its decision recognized that we moved for summary judgment on that issue, but then failed to address it in the court's decision.
Right, the court's decision was all on storm in progress. Correct?
Correct.
And the judge, even if there is or is not a storm, I mean, if there's, you still got to deal with the constructive notice issue.
Correct.
And the court never ruled on it, thinking perhaps that the storm, there are some issues that are common to constructive notice and storm in progress, but I think the court thought maybe they were one and the same. And you claim, do you want us to rule in the first instance on constructive notice, or should we send it back down?
I think on this record, you can make a decision on constructive notice and dismiss the case.
Okay.
Because I think the proof was in the record on both issues, the arguments were made, counsel had a chance to respond to that, and we did establish a prima facie case in that we have a situation where we presented a witness, Julie Swan, who lived on the premises, and she said that there was no buildup of snow or ice before that day, that any precipitation, any snow on the driveway fell that day, that she was out on the driveway earlier that day and she didn't see any ice, and that the landlord had a snow plow contractor that came by to plow, and that he came to the premises once a week to make sure that things were getting done.
Is the record clear as to the last time he checked prior to the fall?
It isn't, except to say that he came weekly. But the reason why we feel that that isn't crucial is because we have Julie Swan. And here's this independent witness who resides on the premises, who says, I'm there every day. There was no buildup of snow or ice on this driveway. And on the day in question, I was out there earlier in the day, I did not see any ice.
Right, but there's other witnesses who claim they did see ice.
There's only
so there's
one
an issue of fact on that.
There's only one witness who
Mr.
claims
Smith.
to see ice, Mr. Smith. And Mr. Smith claims he sees ice at 10 p.m. on the night of the accident. The accident's at 10:30 p.m. And he's sitting in his car out in the street, and from the street lights, he says, I see a glare on the driveway. I think that's ice. Let's assume, for purposes of the plaintiff, that is ice that he sees. What Ms. Swan says on the issue of notice is that there was no buildup from a prior storm, number one. Number two, that when she's out there earlier in the day, she only sees snow, fresh snow that fell that day. And we have a meteorologist who says that the snowstorm was that day and snow fell that day.
A snowstorm in Buffalo, 1 inch over 2 days. Is it storm? That's a pretty nice day.
Well, there are worse days. There are worse days, but the case law recognizes that a trace accumulation over 24 hours as part of an area-wide storm can constitute a storm in progress.
Yeah, the problem with that argument, though, is that even the records that were submitted show that this light snow stopped, I don't know, 4 or 5 hours before the accident happened. But I think your constructive notice argument, as I understand it, is this woman said there was no ice earlier. Arguably, this other witness said about a half an hour before the accident happened, he saw some glare, and so there might have been ice. So the question is whether there was a reasonable opportunity at 10 o'clock at night for your client to do anything about it.
Yes.
And whether it was reasonable to require him to do something about it. This is a private home. It's not a business. It's not a supermarket. It's not something where people are traversing the area regularly, invited in as like they would be in a business. So that's really the question before us on constructive notice, right?
It is. We've got the best case scenario for the plaintiff. We've got the period from 10 p.m. when Mr. Smith sees what he sees and the accident at 10:30 on a residential neighborhood on a Monday night.
We recognize, as Justice Perdomo pointed out, is whether or not it existed for a sufficient period of time that put your client on notice, constructive notice.
The only proof about the period of time is that half hour.
We got it.
On the issue of the storm in progress, Your Honor, I believe you're mistaken about the 4 or 5 hour time period. If you look at what the meteorologist said, the meteorologist...
I did, but I also looked at the records that he relied on, and the records show that the last recording of light snow was at 5:54, was during the 5:54 p.m. hour.
One of the things that the meteorologist relied upon were the Doppler radar images. And the Doppler radar images were for the period from 9 to 10 p.m. And during that period of time, they document continuing precipitation of a level that's colored, it's graded on the Doppler radar image. They grade the intensity of the precipitation, and that is objective proof from that radar system of these continuing bands of snow that were coming down from the north, heading southeast across that county, as we typically see in the winter, and they're shown right on those radar images right until 10 p.m. And the meteorologist, looking at everything, rendered his opinion that it was snowing
trace snowfall
up to 45 minutes before. And this, if the court, what the court below did, and if this court affirms the question of fact on the storm in progress, this would be the first case ever where a plaintiff a defendant proved a prima facie case under storm in progress with a meteorologist and certified meteorological records, and the plaintiff was able to create a question of fact without a meteorologist based on arguments that sound like a lull in the storm.
That assumes you met your burden with this evidence.
Correct. It does.
Thank you, Counsel.
Thank you.
Good morning.
Good morning. Brian Noth, the Tempio Law Group, on behalf of the plaintiff respondent.
So let me ask you a quick question. So you agree that that bill of particulars was utilized for both parties?
That's not my recollection, Your Honor. I would have responded individually to each defendant's bills of particulars because they would have been, probably formatted differently and questioned differently as far as that goes. So my recollection would be there would be separate bills of particulars.
And is your argument here today really focused, I'm trying to gather into what we're looking at, on the constructive notice argument? Because when we deal with creation or we deal with actual, those kind of things, I don't see much. I see your focal point is the constructive.
I would submit that, Your Honor. I mean, obviously, actual is always somewhat difficult to establish. But in this particular case, pointing out with respect to constructive notice, there's no proof in the record as to when the defendant was last out there.
Okay, before you get to constructive notice, I just want to follow up on Justice Sentra's question. The bill of particulars and supplemental bill of particulars that we do have in the record that was responsive to the co-defendant's demand states that the plaintiff is not aware of any notice to the defendants, plural. So, again, I would like to know whether actual notice is in this case or not.
No, we would submit that actual notice is not in this case.
You're not alleging creation of any dangerous condition?
We're not, because
failure to sell, failure to shovel isn't creating anything, right? So all we got is constructive notice left. That's your theory?
That's our theory, yes.
Okay.
And with respect to constructive notice, the defendant failed to submit any proof whatsoever as to when the defendant was last out there and inspected it. He hired a plow guy, but he testified that the plow guy wasn't out there that day, March 4th. He couldn't say that the plow guy was out there the day before or the day before that. So we would submit that, at the very minimum, defendants failed to satisfy his burden with respect to establishing a prima facie case of lack of constructive notice in this particular case. There's absolutely simply no proof whatsoever. Moving on to the storm in progress, as court pointed out and mentioned earlier, the trace amounts of snow, if you even believe that they were occurring on this particular driveway, really begs the question of a storm in progress, especially something that's occurring over 3 days. In fact, Julie Swan mentions, hey, it's Western New York. And that's exactly what we would submit as well, that it just begs the question of trace amounts of snow, if it actually even fell in this particular driveway. We would point out that with respect to my client's testimony and his cousin's testimony, if we take a timeline and we go through the day in question, he has no recollection of any snow falling. He goes out earlier in the day at some point in time while it's still daylight out, and there's some testimony that it gets dark around 5 o'clock. So somewhere prior to that, he goes out to start his car, doesn't brush any snow off his car at that point in time, doesn't see any snow falling at that point. He comes out later around 5:30 to get picked up to go to see his friend. There's some question about whether he can remember whether it's anything snowing at that point in time. But later in his testimony, he says that between 5 o'clock and 10 o'clock when he came back home, there was no snow falling. Mr. Smith testifies that when he dropped him off, there was no snow falling. Mr. Smith also testifies that at 10 o'clock, he could see ice all the way back.
Well, no, I'm not sure you used the word ice. You could see glare.
He first said ice, and then when he was questioned further, he said, I saw the light shining, because he was questioned about the light and whether he could see from the street up with respect to the light that was coming off of the street lights. He initially said ice, and then he said glare off of something that was on the driveway. I'd also point out that when Mr. Smith came back to help the plaintiff after he fell, Mr. Smith testified that there was no snow on the sidewalk in front of the houses, which again begs the question, did any snow fall that day out there? Or if snow had fallen, somebody apparently had time to go and clear the sidewalk in front of both the houses prior to when this incident
On
occurred.
most constructive notice cases, we have the defendant, be it a supermarket, something falls on the floor, these snow cases, they have a record of some maintenance person or a snow plower. Here we've got the property owner's got some guy who he doesn't know when he shoveled, has no idea when he plows, knows nothing about what this guy did or when. So your argument is that's not enough to meet their initial burden.
Exactly, and there's also no proof that this snowplow guy, if he came out, would ever just simply inspect the area or just go and salt the driveway if we just saw ice on the driveway. There's no proof of that. And again, there's no proof of when he was out there, other than they do say that he wasn't out there that day, and his pattern or his procedure.
I'm not even so sure how relevant that is, because we're dealing with, this isn't a commercial type of situation, scenario where we've had cases dealing with supermarkets, BJ's. I'm not so sure this requirement that you have to do so. I think we understand your argument, though.
Your Honor, if I could just respond to that. This was actually a boarding house. This wasn't a residential house. It was a boarding house where people paid rent to live in his house. And, the people next door also had the right to use the driveway to move back and forth, and he was aware of the people moving back and forth through this period of time. So we would submit that, in essence, it is a commercial environment. Thank you, Your Honor.
536 Grimshaw v. Carrillo, Jr. Good morning.
Good morning. May it please the court. Keith Miller for the defendant, James Carrillo. This case seems to center around nightlights and whether there's some sort of a duty to provide that. It is our contention that this case fits more within the Koval case that we cited in our brief rather than McKnight. This court has held there to be questions of fact when there's confusion. Two doors looking alike in a dark hall where the switch is at the other end. In this particular case, there can be no confusion about the bedroom and an open stairway. The plaintiff cites this as some sort of an unguarded stairway. Well, last night there were probably 50 million unguarded stairways in the United States, including, I bet, in some of your houses as well. There's no duty for us to guide a person or warn a person of this when they have actually gone up the stairs. Can you imagine that, we impose, Mr. Carrillo would have said, hey, look, stairs.
Well, going back, as you make the distinction between two cases, we're dealing with a situation whereas in the Koval case, there's no lights available, dark hallway, It's a case myself and Justice Lindley sat on, and then the McKnight case that's cited by plaintiff also sat on Justice Lindley and myself, where the circumstances there are different.
They are.
We recognize. Here we have a situation that, what you're saying is that because they went up the steps, she was aware of the layout, went into the room, came out of the room. I read the deposition. She knew that where the switch was for the lights. She could have turned it on. She chose not to. Went into the bathroom, and unfortunately, and it really is an unfortunate situation, took a few steps the wrong way and ended up.
It absolutely was. And in pages 16 to 18 of the record, that's where she talks about, she knew the master bedroom was to the right. She knew the stairs were straight ahead. She had, as far as providing light, there are photos showing there's a light right above the landing. The landing is...
There was proof that there were appropriate light switches to illuminate the hallway, the landing, the stairs. There was a handrail. There's no code violations, which distinguishes this case from McKnight.
And that's...
She had just operated the bathroom light and turned it
Well,
out. That would have illuminated the hall.
And that's just it, is that I even asked her, did you wait to adjust your eyes to the dark? And no, she didn't remember doing that at all. Again, going back, just flipping on a light to get your bearings. There's some sort of criticism about a coach light out in the middle of the yard. And if you look at that, the shadows from that actually don't show up in the second floor. They show down in the dining room, and I provided photos for that. And that's...
Well, it's part of the argument that there should have been some sort of ambient lighting, right?
And I can't find a duty for that anywhere in the records.
That's the question.
Well, let me ask you this. Do you need your expert's affidavit to prevail here? Because the other side challenges the admissibility of your expert's affidavit because he doesn't set forth his resume and his training and experience. Do you even need that to prevail here?
I don't believe so, but I put that in because if you look in the bill of particulars, there are accusations of improper railings and improper treads and things like that. And I pointed out in my brief, this is a very different case than the cases that are cited by the plaintiff in this. In those particular cases, you're looking at an expert who is saying, hey, this particular aircraft design is safe.
Really wasn't even an expert opinion given here.
I could have used someone from codes to do that.
You could have done it.
I could have done it, absolutely.
There was no, just as Wendell indicated, the expert's affidavit was, he may be an expert, I don't know, we haven't seen his resume, but he just gave factual observations of the layout.
He's a professional engineer that entitles him to be able to read and to both a code book and a tape measure. And that's all he did. And remarkably, with all the time that they had and all the resources that the plaintiff's attorneys had, they haven't come forward with anything to refute that. And so everything meets code. There's plenty of lighting, plenty of opportunity. There's no further duties that Mr. Corello had to do. He didn't have to warn them of the stairs, didn't have to guide her to the bathroom. She actually got there.
So this is Koval, not McKnight.
Absolutely.
Okay, thank you, Counsel. Good afternoon.
Good afternoon. Good afternoon. May it please the court. Kelsey Shannon for the plaintiff. I will very briefly touch on the expert issue. The cases that the plaintiff cites are not products cases. Flanger and Steyer are premises cases. But I think Justice Lindley is right that is somewhat of a sideshow here. The question is not so much whether the expert testimony is admissible, because I don't know that their argument or our argument rises or falls on that. I think Mr. Miller is correct and Your Honors is correct that the question is whether this is McKnight or Koval. I think if there is to be a synthesis of those two cases, the synthesis is the plaintiff needs to identify negligence by the defendant. And I'd submit here that the negligence is in the facts of this case and in the particular circumstances that Mr. Grimshaw and Mr. Corello and Ms. Grimshaw found themselves in that evening. There was negligence on the part, or at least a triable issue of fact of negligence on the part of Mr. Corello.
Right, because because he turned off the lights when he came up.
So sure, I'd start with the design of the house, which places the stairs a couple of steps away from the bathroom and essentially a wrong step away from the...
Yeah, but once again, there you're getting into a couple steps. I think it was measured 40 inches and a half or whatever it may have been, but for all intents and purposes, you don't have an expert saying that it was a faulty design.
And
you don't have an expert that
and
says
I agree, and it's not, there's no evidence in the record that it violates codes, doesn't need to violate codes in order to constitute negligence. I think standing alone, maybe that would not be sufficient. Miss Grimshaw had been in Syracuse, let alone the house, for a matter of hours. She flew in earlier that day. There is some equivocal testimony in the record that they did a tour of the house. It is assumed, I think, by defendant that that tour included the upstairs and the bathroom, but there's nothing explicit.
We know that she went up those stairs to go to the bedroom.
She did. So prior to when they retired for the night, she went up the stairs. As she did, the defendant turned off the lights.
That was
but
later
yes,
when he went to bed. She went to bed ahead of him.
and he comes after. Yes, that's correct. So she has been up there, and there's no dispute about that. There's no.
The bottom line seems to be whether he had some sort of a duty to leave some sort of lighting on for her because she was a first-time guest in his house, right?
I think a duty either
to
to leave lighting on or to say, hey, you've never been out there in the night, watch out, the stair is right outside of the door.
Right. Your case would be a little bit better. Look, this is a tragic case. She ends up paralyzed falling down the stairs.
Yeah.
And horrible case. I think your facts would be better if, coming from the bedroom, where she was for a while, if she fell en route to the bathroom, but she got to the bathroom safely, turned on the light. If she had just kept on the light, Justice Wendell mentioned this. She kept on the light, didn't turn it off. She can see where she's going. She doesn't fall down the stairs.
I agree. My case would be better, but I think once you accept the premise that if the other fact pattern, right, had been actionable negligence, then maybe what you've just described is comparative negligence on the part of my client, but does not eliminate the negligence on the part of the defendant.
To interject one more factor, when I looked at the photos on the record, there appears to be a hall light switch right there outside the bedroom.
Well, there's a hall light switch right at the landing, right at the top of the stairs, right?
Well, it's right next to the bedroom door. And correct me if I'm wrong, that's my recollection.
Yeah, I mean, I guess this is the problem with the design, right? Which is that the doorway to this, they're all right next to each other, right? And right between the door and the bedroom is a light switch. I don't disagree with that. I think, could she have reached that and turned it on? Yes. Although, could she have also reached that and again made the same misstep? I think that's possible too.
Well, your best argument in the end run is negligence involves reasonableness. Reasonableness is usually a question of fact for the jury. And this case should go to the jury to determine whether there was a reasonably safe condition.
Yeah, I agree with that. And just to expand very briefly, and negligence and reasonableness is in the context of the particular circumstances that took place there.
Thank you.
Thank you, Your Honor.
357, Furch v. Klinger.
Good afternoon, Your Honor. May it please the court. Patrick Maloney from Dempsey & Dempsey on behalf of the plaintiff appellant Francis Furch. As you're aware, this is a car accident on July 24, 2013 at Pittsford, Palmyra Road in the town of Perriton. A verdict was rendered in this matter, and this is a motion to set aside the verdict and overturn the lower court decision, as in this case the question of negligence and causation of the accident are inextricably intertwined. Under the number of cases that this court has put down, Reed versus Levy, Morgan, Cabon versus Pisani, Murdoch versus Stewart's Ice Cream, a verdict of a finding where the defendant was negligent and that was not a cause of the accident, could not be reached under any fair interpretation of the evidence.
You seem to argue that if the jury found they violated 1129 of the vehicle and traffic law in and of itself, that they had to have found that they were the proximate cause of the accident.
No, Your Honor, actually 1129 was charged because I needed 1129 versus Mrs. Slate, or Mrs. Klingler. Because we had to charge that because that was our theory that she never stopped. There were two totally opposite stories in this case.
Right, and your argument is that following too closely, the jury evidently, in your view, believed that she came to a complete stop and did the chauffeur stop, which I'd never heard of. Didn't know chauffeurs stop that far away, but that since they believe that she stopped, then the theory of following too closely is out.
Right.
Because there's no law that says you can't stop too closely.
Exactly, Your Honor.
That's your theory, but Mr. Schul talked about in the motion below a third way. I mean, the jury, isn't it possible that they can reject both of your theories and come up with what he calls a third way, and as long as there's evidence to support it? And
except they found her negligent, Your Honor.
That was I started to ask my question. Maybe I misspoke, but you appear to have, the following too closely is where I'm looking at it. And the theory is that you're saying because she stopped 5 feet without a chauffeur's length, whatever language that was used in the record, that she stopped closely, that when she was rear-ended by the other defendant and hit that car, that's not following too closely.
Correct, Your Honor.
So they couldn't have found her following too closely under 1129 because she wasn't following too closely.
Exactly, Your Honor. Okay,
so that's the thing. And going back to Justice Lindley's questions, it seemed to me is that, I got to be honest with you, it's interesting in this respect. We have the plaintiff's story that he was rear-ended twice, and he's got damage on the left side of the bumper and the right side of the bumper. We have testimony from the plaintiff and the plaintiff's foster child, whatever, two separate testimonies that said there was one impact, okay, period. Then we have the testimony of the defendant who rear-ended this defendant, and she claims there was only one impact, although I think you made it abundantly clear during the cross that, you know, she was distracted and that's all she saw. And then we have, on top of that, going back to this jury verdict, we have two experts. One expert, your expert, says it has to happen this way, they have to be traveling at this speed in order to deploy the airbags, and then the defendant has their expert. So, you know, our job, and I have an interesting case, is really looking at, is there an explanation? Is there plausible, as Justice Lindy said, that the jury could come to that conclusion? Could they disregard some testimony or not? You seem to be arguing that they can't, if they had never checked negligence on the box, if they never found the defendant negligence, you obviously would be in a different posture right now.
Absolutely.
Okay, and so to me, the way I read your brief, and I'm wrong, and correct me, it appears that you really focus in on the fact that once they found negligence, henceforth, they had to have found that, because they're intertwined.
Absolutely, Your Honor. They are intertwined in this case because of the very nature of the case.
Yeah.
This jury had every opportunity not to find Ms. Klingler negligent. There was a third party, Ms. Slate, who said, it was me, I did it. I ran into everybody.
So this verdict was legally inconsistent.
What's that?
In your view.
Yes.
This verdict was legally inconsistent.
Legally inconsistent.
And we know that in criminal case, you have to object before the jury's gone. And there's a rule in civil law as well. You have to object, and the reason is, if the verdict's inconsistent, while the jury's still there, you send it back in and say, hey, sort this out. There was no objection here, right? It wasn't preserved.
There was not, Your Honor, and in hindsight, and after doing some appellate work, it would have been better to object, but I think what that takes us to then is the Reed case, where we now move to the motion to set aside the verdict.
And the weight of the evidence, that basically the weight of the evidence swallows the whole rule that you have to object, which doesn't seem to make any sense.
But when you look at the decision that Justice Manerick made, Justice Manerick at page 32 of the record states, defendant then testified that she was indeed following behind plaintiff and had to stop abruptly when the vehicle in front of the plaintiff stopped to make a right-hand turn. That's just not true, and it's not anywhere in the record. If you look at the record on page 98, Klingler says, we were approaching Krieg coming up just down this little slope. The car stopped, the truck was stopped. There was a red Toyota in front of him. I slowed down. I was practicing the chauffeur's rule. I watched. I stopped so I can see the tires of the vehicle in front of me, and I could see the tires on his truck, and I stopped. Under any circumstances, if you believe Mrs. Klingler, she was not negligent. But they found her
Couldn't it be
negligent.
this? And believe me, when I read your brief, like, wow, this is, you got some point there, but couldn't it have been that they believed that Klingler stopped? There weren't two collisions, there was just one, that Klingler stopped, but that Slade, the third vehicle, was going so fast that regardless of, if she was negligent in stopping too closely to the car.
But then they wouldn't have found her negligent. First of all, it wasn't argued. Secondly, there was no evidence to that. There was no evidence by anyone put forth by Mr. Schul or myself or argued anywhere before the jury that she stopped too close to this car. In fact, her testimony is the opposite.
See, the problem is, but the jury, the question becomes this: could the jury reasonably infer from the testimony that was there, that they heard, whether or not that if she had stopped 10 feet, but by stopping too close, just stopping too close, she put herself in a position that she could have impacted the vehicle. Whereas if she stopped 10 feet prior to the bumper and was hit from behind, she never would have made contact with the defendant.
If that is the case, the jury is then making up a theory of their own that was not argued, was not supported by the facts.
And that's what you argued in your brief.
Correct.
But the record, I was curious, the record that you put together omits all the closing arguments. You aware of that?
I was not, Your Honor, I didn't put.
It goes from page 293 from 292 to 293, and then I'm looking for the summations to see what Mr. Schul argued, what you argued, and it goes right to the jury instructions from the last witness for some reason.
I have no idea why, Your Honor.
I think we understand your argument.
Thank you, Your Honor.
Good afternoon, Counsel, or Your Honors. I just want to reiterate that this was a very astute jury when you look at the whole thing, because when you look at Judge Menard's charge, she told them, if you find that 1129 was violated, it is negligence.
Can you follow too closely when you stop? If you're stopped too closely, is that a violation of 1129?
Yeah, I mean, that's my interpretation. I think that's a fair interpretation of what this jury did with this case.
You don't have to be moving to follow, I guess?
Apparently not. I mean, it was charged without objection, and it didn't distinguish between Klingler and Slate. And it's very clear when you read it, because the court charged on 1129, and the very next paragraph is the charge on proximate cause. So it follows very logically a very smart jury that paid attention and followed the judge's instructions and reconciled the facts and the proof. And what I provide is a fair interpretation as to how they reached their decision, and we shouldn't set aside the verdict on those grounds.
Thank you. 538, 539, Manja v. Gonzalez. Did my best, okay. Good afternoon.
Oh, my gosh.
Good afternoon, Your Honors. Greg Pajak for the plaintiff, Jabbar Al-Mughnahi, and this is going to be deja vu.
Take my best.
It is deja vu.
It's complete deja vu. It's a very similar circumstance. Obviously, the jury found the defendant negligent, but not a proximate cause. And my argument is very similar to Mr. Maloney's, which is that the jury could have certainly in this case said that the defendant was not negligent. I wouldn't have taken an appeal. I'd have no basis because there were competing theories about what happened. But once the jury agreed that the defendant was negligent, and the only way they agreed is because they accepted my argument, which was that the picture at page 311 of the record, which is that long view up the hill on Ridge Road where you can see, frankly, to the tippy top of that bridge. I said the plaintiff on his bright red bike was in plain view coming down. The plaintiff said he popped out right in front of him, didn't just hit the side of the vehicle, and that's what caused this accident. And the jury must have agreed yes, because they found the defendant negligent.
You know, I guess the weakness with the argument that I see is this is a problematic intersection. It seems to me that, like, the plaintiff, as first of all, he's riding his bicycle on the wrong side of the street.
Which you can do there.
I know, but
So it's not the wrong side.
But there's a bike path on the
Sure.
other side. But the problem is, as he's approaching this intersection, and I forget what the two streets are, it's Ridge
Lehigh.
and something, he can't really see the vehicles that are approaching from Lehigh until he gets right to the intersection.
Correct. And that would
So-
go to his comparative negligence.
Well, maybe not. I guess, couldn't the jury have found that perhaps the defendant who, there was proof he had inched beyond this white line so that he could better see the sidewalk, you know, what was approaching from both directions, and particularly the traffic that was traveling from his left. He had advanced beyond this white line, had been sitting there for about 15 seconds. There was at least proof along those lines. Couldn't they have found that he was negligent for not looking back to his right, but that it was your client's fault who was the sole, or it was your client who was the sole proximate cause for not stopping before he got to that intersection when he didn't have a clear view of what might be coming?
The reason I would say no, and I understand that argument, and that is what Mr. Green is making here, and that is, again, it's the record of 311. The view that the defendant had that he was stopped at the stop line, not when he went over it, when he was stopped at the stop line, he said that is the photograph which depicts his view. And you can look, in fact, I see a bicyclist up on top of the bridge or something coming down.
But if that was before he had gone past the white line, and he was past the white line for 15 seconds, isn't it reasonable to conclude that the plaintiff wasn't even in his view at that point?
The plaintiff was riding a bicycle, not a rocket, okay? The plaintiff was coming down the hill on a bicycle. A bicycle only goes so fast. And that was the suggestion that the defense made. The plaintiff was going so fast, it is impossible for there to be a bike, not even at the crest of that hill, and that's the only way that the defendant would not have seen him, is if he was on the other side of the crest. And you can clearly see all the way up to the top of the crest. There's no way a bike is going to come from top to bottom in
15 seconds or more?
not one chance. If you look at that, I also know that road. There's no way, okay? But again, the jury rejected that argument in finding that the defendant was negligent. That was their argument. And the jury said, no. They bought my argument, which was that he was there to be seen.
The defendant was negligent in coming up to the white line without looking, I guess, and seeing your client on the bike.
He says he looked once and he didn't see him.
And he's focused on the left.
He didn't look back.
Correct.
But yeah, and just paired out to indicate, this intersection, you have a stop sign.
Right.
And then you have to go up to a white line to stop.
Correct.
Usually the white lines are at the stop sign.
It's a terrible intersection. But the problem is then again, that's page 310 of the record. And this is what the defense did in their closing. They were conflating, frankly, page 310 and 311. And they were trying to suggest, and they were holding up page 310. Now, our closing arguments are in the record. And if you take a look at those, they're saying he couldn't have seen relative to the defendant. But this doesn't matter because this is not the defendant's view. So as bad as the intersection was and is still, it doesn't matter because this was his view according to the defendant. He can see all the way up the bridge. He said it was 30 feet. He was terrible at estimating. It's obviously a heck of a lot more than 30 feet. So this is the picture which showed his view, not the terrible intersection part. So once he gets up there, he's duty-bound to see what there is to see, and he never saw my client proceeding, and the jury accepted that. Again, they could have said the defendant was not negligent. I wouldn't be here.
No, that's like the last case. That's the aspect. How do we grapple with the fact that they take the first step and then they stop and then, you know.
And I won't say, like Mr. Schul, that this was a very smart jury. I don't think my jury is very smart at all. I don't know. They completely screwed this whole thing up, to be honest. But the reality is they are inextricably interwoven here. They said yes on the one. They had to say yes on the second. Thank you.
I suppose you think this was a court or?
Good
Good friend, Mr. Pajak.
Smart jury, huh?
This jury was brilliant. PhD.
Oh, Lord.
Now, what really, there's, the issues are no more inextricably interwoven here than they were in this court's decision, leading decision in New York in the Skowronski case, which I could quote and did quote in my brief. I'm not going to read it over again. And there's a wealth of decisions which, by analogy, argues forcefully that there's no issue of the questions being inextricably interwoven here. This is a nasty intersection. Gonzalez said he could see no more than 30 feet up. If you stop at the stop sign on Lehigh, you can't see 30 feet up. So you have to inch forward to where that white line is that's depicted in the photographs. Then you're confronted with a stone wall with a railing on top of it. Now,
Do you dispute that the defendant had a view to his right up the sidewalk where the plaintiff was coming from?
No, I do dispute that. I do, based on the testimony. I believe the testimony was 30 feet, but that's more important because coming down the bridge, the plaintiff testified he couldn't see the car until the last minute. What's interesting about that in terms of what the jury could have found? On pages 168 and 169 of the record, and reiterated on 174 of the record, this is the plaintiff's testimony. I'm not sure whether the car that I hit was moving or stopped when the accident happened. Here's the problem. You come down to Lehigh and neither party can see the other. And what you have is the primary focus of Gonzalez has got to be to the left because he's telling you that there's a lot of traffic on Ridge Road in the direction that he's turning to the right. So he can't pull out in front of traffic.
So what's the negligence that they found? What's your theory?
I think the negligence is that he arguably inched up to a point where he was in or impinging on the road, i.e., and traffic coming down from the sidewalk on the bridge. But the negligence of the plaintiff was what I think the jury found was primary. That's my guess. You have to look and to see, based on the law as we know it, that the jury has to be based on a fair interpretation of the evidence. And if you interpret the evidence,
right, there has to be some explanation for that.
Then you really say the plaintiff never saw the other guy. He's coming down the bridge on a bike and he runs into the car, which was in his path. Being in his path, arguably, according to the jury, one sensible view is that was negligent. Well, it was, but it was not negligence that was a substantial factor because of the other circumstances, the traffic, the head on a swivel to determine whether or not he's going to pull out in front of traffic that's moving on Ridge Road from a west to east direction. If anyone has any questions, I'd be happy to try to answer them. Thank you.
541 Infernatio v. Rochester Telephone Company.
Good afternoon, Your Honors. May it please the Court, David Benz, appearing on behalf of the plaintiff appellant respondent. Your Honor, it's our position that the court below erred in denying plaintiff's summary judgment motion with respect to its claim for unpaid rent. This relates to a commercial building that Frontier Telephone indicated it via letter dated July 26, 2001, that it was going to surrender possession to. However, the facts of this quote-unquote abandonment were such that keys were not surrendered until September of 2001, mid-September, and there were several drums of some substance marked as hazardous waste were left on the premises. It's our position that the chemicals, but even more importantly, the keys, the failure to surrender keys did not amount to surrender to the premises until September because of the fact that my client was not put back into possession. My client was not given the ability to access the property. The keys themselves, with the keys to the building, he could not access it, therefore he got no benefit of being returned to possession. And under the law, if he has not been put back into possession, he is entitled to treat the tenant as still being in possession and recover rent for that period of time.
So is there a question, the court below found that there was a question of fact as to when the surrender occurred?
I think that there was a question as to that. More importantly, I think they focused on the drums as opposed to the key element. And
as to whether, and there's a suggestion, windshield fluid or something.
yes,
Some substance.
I think it was determined after the fact, but it was.
And whether it prevented all use of the property or blocked it off in some way?
Right, well, I think, the standard when you have something like, I think there's a case that is relied upon by the respondents that suggests that if you've got garbage or something that's left of the premises, that's not.
waste.
Yeah, that's
Right.
not enough to raise it to denying possession back to the
The court
landlord.
ultimately determined, based upon the facts, based upon what was left behind, they thought it was a question of fact.
Well, and even if you want to focus on the drums as perhaps being an issue of fact, this failure to surrender the keys, I think, removes that from the equation, because the keys denied my client access, and there's no dispute as to when the keys were surrendered.
Right,
There
but
was
there's an issue
correspondence.
of fact as to whether it was reasonable. They claim they were looking for your guy, and they couldn't find him, and you say, I know you say, well, he lived in the same house in the city of Rochester all this time, but there's some issue there. But aside from all that, whether these two drums are the keys, two drums that are outside, that don't inhibit anyone from making use of the property inside, aside from all that, we have the bankruptcy claim.
Correct.
Against Global Crossing.
Correct.
For $6,000 that you got $309 on. Judge Rosenbaum said there's issues of fact with respect to the scope of that claim. Now, I guess you're arguing, you're asserting now that that was just unpaid taxes.
Correct, Your
It
Honor.
didn't deal with rent.
Correct, Your Honor.
How do we know? There's no, there seems to be issues of fact abound there, and why wouldn't you go after Global Crossing, make a claim for the rent as well? Why just go for the unpaid taxes rather than the rent?
Well, I think at the time, this was prior to our involvement, Mr. Infernato received a proof of claim form, tried to essentially fill it out himself, was not the most sophisticated individual. He made reference to the taxes. He also made a notation about the fact that he essentially had these property damages and a rent claim, and didn't know, and I think indicated he didn't know who the proper party was, but he made reference to it in the bankruptcy proof of claim. The bankruptcy itself, by all appearances, although they addressed the tax issue, that was the one, they didn't address the other rent claims or anything. They sure didn't pay for it.
Did your notice of claim, proof of claim, say anything about rent? Did it use the word rent?
It made reference in, there was a line item for a dollar amount that talked about it, and he referenced taxes, and then there was a separate attachment page that made reference to those other items, and none of that was treated in the bankruptcy court. He was only paid on the tax issue, so at the very least, they didn't treat it there within the bankruptcy, but I think if you look at the documentation that actually, the few documents that we actually have exist, show that, if anything, it's clear that Global Crossing was not the proper party for the rent and the damages claim because of the timeline. There's a letter in April of 2001 that's from Global Crossing that says we're selling Frontier Communications to Citizens Financial.
Right, but that didn't come final until June 29th of that year.
Correct. It didn't.
But you're on appeal, just to be clear, you're waiving, you've abandoned the unpaid taxes claim, which I think is the second cause of action.
That is correct.
So that's, you don't mind if that gets tossed?
That is correct.
That's obviously barred by the bankruptcy.
Yes.
Okay, so we can get rid of that?
Yes.
So now we're just talking about 1 month's rent that you waited all these years to sue, and then you finally sue it, and then you wait 8 years to bring a summary judgment motion without any discovery, and now you get a ruling against you in 06 here? Justice Rosenbaum ruled against you in 2016, right?
Correct, Your Honor.
And now here we are 3 years later.
Right.
It seems like what they suspect is you're taking this really small claim for 1 month's rent and trying to get interest forever and just delaying the case, and that's what they think is going on.
Well, Your Honor, if I may address that point, it's not, there isn't just a claim for the unpaid rent. There's a claim, there's actually a much more significant claim for the property damage. The tenant was obligated. That's not part of this appeal because our motion for summary judgment was just on one of the claims, the rent aspect. Because in my opinion, at that point, I thought that was the clearer thing that was subject to something that could be resolved via summary judgment, where I recognized the damage issue would be a separate issue that had to be dealt with at trial. In terms of the timing, Your Honor, I can only speak that In terms of, I know this is an old case.
17.
Yes, Your Honor.
It would be considered old. It was as old as the criminal case we had.
I drafted the complaint back in, I believe, 2007 as an associate of law firm that no longer exists. I lost touch with it at that point. It was handled by a partner, and I don't know.
Later, there's a summary judgment motion with no,
right,
and then no discovery. But has the trial gone on? Justice Rosenbaum issued this decision in October of 2016. Did he stay it?
Yes. So, Your Honor, there was a decision issued. We actually tried to appeal this before, and it essentially was not noticed that he issued a decision, but he did not characterize as a decision in order, so that it got bounced back on a technicality, so we had to restart the appeal process, and then we decided to consolidate the appeals, so that there was some timing involved in that. At this point, Judge Rosenbaum essentially stayed the requirement to file a note of issue pending this. With respect to the discovery aspect, Your Honor, I realize this is an old case, very old case, but I'd argue that discovery, albeit on the very...
What prohibited discovery from taking place?
I'm sorry?
You acknowledge all this time has passed. What prohibited plaintiff from doing discovery much earlier?
Again, I can only speak to when I handled the case briefly in 2007, and then I don't know what the circumstances were within the firm itself.
But you acknowledge that the trial court has discretion with respect to such
I do, Your Honor. I acknowledge that, but I guess I would point out that when I became involved with the case in 2015, almost immediately, I filed the initial motion for partial summary judgment. At that
Are you
point in
saying
time,
that the court shouldn't look at what had not occurred all those years prior?
Well, no, I'm not saying that, but I think they should perhaps take into account the fact that neither party had moved to essentially say that neither side is entitled to discovery, and there was no scheduling order in place, technically speaking, so that we had no conference with Judge Rosenbaum was complaining that this needs to be done.
What do you want discovery on? What issues do you think you need to?
Trying to sort out the morass of which entity
When
was
Global
involved.
Crossings sold to Citizens.
Correct, and
You
the
go on
circumstances
Google.
of that sale.
You could go on Google and in 20 seconds find out that date, that the transfer took place on June 29th.
But it's more than just
2011.
the date, Your Honor. It's the circumstances,
2001.
what obligations they assumed and things like that we're trying to determine as well.
Okay. All right. I think we have your argument.
Okay, thank you.
Good afternoon.
Good afternoon, Your Honors. My name is Craig Peterson. I'm with the Glennon Law Firm, and we're appearing on behalf of Frontier Telephone. This case is unique because plaintiff has pursued Frontier for nearly 18 years after seeking payment from Global Crossing, which had acquired Frontier Telephone in September of 1999. Global Crossing subsequently filed for bankruptcy in 2002. This appeal has its genesis in the termination of a month-to-month tenancy in July of 2001. In a letter dated July 26, 2001, Frontier Telephone advised plaintiff that Frontier was terminating its occupancy at 650 Whitney Road in Fairport, and that Frontier had already vacated the premises. The letter also stated that rent through August of 2001 had been sent. Issues arose because plaintiff felt the rent checks for July and August in 2001 did not include a consumer price index increase of $378 per month, and there were either 2 or 4 55-gallon drums filled with windshield washer fluid and used motor oil, which were left at the premises awaiting pickup by Frontier's waste hauler, and that the defendant could not locate the plaintiff to return the keys until sometime in mid-September. From these facts, plaintiff claims that Frontier was a holdover tenant for that September 2001 period. About 1 year after Frontier vacated the premises, plaintiff sought to collect the same damages alleged in this particular lawsuit by filing a proof of claim in Global Crossing's bankruptcy.
Do we know if they sought the rent for September 2000, or whatever year it was? Do we know if
2001.
2001 they were seeking rent in the bankruptcy?
Yes, Your Honor.
How do we know that?
If you look at the proof of claim filed in the bankruptcy, and we've attached a clear copy to our, as an appendix to our brief, it does state that they were looking for what they called were unsecured priority claims of taxes, And then they refer also to, please see attachment. And the attachment to the proof of claim seeks $500,000 for rent, breach of lease, and damage to property. So they did seek those damages.
So if you're right, your cross motion should have been granted.
That's, we submit that that's correct, Your Honor. Just to go through a little bit more of the scenario, about 6 years after Frontier vacated the premises, plaintiffs sued both Frontier and Global Crossing. This is 4 years after filing the proof of claim in Global Crossing's bankruptcy. And as far as the record discloses, there was absolutely no discovery. And plaintiff finally moved for summary judgment over 8 years after this case had been in suit. And the trial court denied both parties' motions and further ordered that no discovery would be had. And here we are today, nearly 3.5 years later, arguing an appeal of an order that denies summary judgment. In my oral argument, I want to be brief, but I want to address 4 issues. First, we contend that the trial court properly denied plaintiff's motion for summary judgment because there are questions of fact as to whether or not there was a holdover tenancy and whether there was rent due for September of 2001. Secondly, we contend that the trial court properly ordered that there would be no further discovery ordered. Thirdly, we contend that the question of statutory interest under CPLR 5001 is premature. And finally, on our cross appeal, we contend that the doctrine of judicial estoppel should be applied in this case to result in the dismissal of the complaint, because plaintiff claimed those damages in the Global Crossing bankruptcy. The plaintiff's motion for summary judgment, as I said, the court ruled that there were questions of fact concerning the date Frontier vacated the premises. Essentially, plaintiff argues that Frontier was a holdover tenant because...
Counselor, as you know, you're very familiar with this court.
Yes.
We've read the briefs, we listened to the arguments. The questions were pointed to counsel to begin with reference to the whether or not what information was present that would give rise to a question of fact. So I think we really gathered. I think the little bit of time you got left, I would spend it on your cross motion.
Okay, I'll be happy to do that, Your Honor. On the cross appeal, plaintiff sought to hold Global Crossing responsible for the damages he now asserts against Frontier in this action by filing the proof of claim submitted under a penalty for fraud of a fine of up to $500,000.
We see it. Once again, we recognize. So the question becomes is the fact that they made that claim in the bankruptcy court, which they did. And obviously, it's clear that you provided us with the proof. And their argument seems to be that the bankruptcy court doesn't specifically address that, just specifically addresses the $300 and some. And so therefore, maybe they made a claim, but it may not have been considered by the bankruptcy court. And I think that's really what they're hanging their head on. And we have to look at whether or not the actual information that was provided, what the bankruptcy court decided, whether or not that is enough for us definitively to determine that that's dispositive of the issue. If it isn't, then obviously there's a question of fact on whether or not it was dispositive or not. And that's really where the focal point is.
Well, if I could just address that briefly, Your Honor. The essence of, or the application of judicial estoppel doesn't depend on whether the party prevailed or not.
Fair enough.
The question is whether the doctrine of judicial estoppel provides that where a party assumes a position in a legal proceeding and succeeds in maintaining that position, the party may not subsequently assume a contrary position because the party's interests have changed. And our position is that in the Global Crossing bankruptcy back in 2002, they affirmatively asserted that Global Crossing was responsible for all of the damages they're now asserting, and because of that, they're precluded from pursuing Frontier at this point.
Thank you.
Thank you very much, Your Honor.
543, Florino Ketch v. New York State Department of DHR. Oh, geez, I passed it. I apologize. I miscalled the number. I'll get to 542. I had it in front of me. Left it, I picked it up over here. Good afternoon, sir.
Good afternoon, Your Honors. Charles Miller, Law Office of Lindy Korn for the petitioner, Ms. Floriano Keach. We are asking the court to overturn the decision by the New York State Supreme Court in Niagara County, which upheld the decision by the New York Division of Human Rights of finding of no probable cause in the complaint by the petitioner to her employer. What we were asking for this court was to review two things in particular. Taking into consideration that we have a long-serving counselor with no problems or history of issues and actually being very excellent, we ask you to take a look at the issue of disability being perceived as a result of being on
Yeah, so your
drugs.
argument is the fact that since they perceived her and maybe having a drug or some type of thing, that is the discrimination, and whether or not that discrimination is the basis of there's a disability here, and that they discriminate against by not interceding and offering her opportunities to address that disability.
Correct, Your Honor.
Okay.
But how did they subject her? Let's assume that she had a disability, the disability being she was addicted to drugs. How did they subject her to what adverse consequences did they have, and what was the hostile work?
Well, that's actually not the question we're asking, Your Honor. The point is they never actually did anything. And the point is they are leaking. The issue is this. There are, case law is quite clear. If you have, are being sent for drug tests, and she was, that's not inherently discriminatory. But in her particular case, we asked to review the record that they specifically thought she was taking drugs typically considered to be addictive, meth, cocaine, things like that.
Yeah, but it came back diluted, right?
Exactly. But they didn't stop their actions against her after that. They kept barring her from things and whatever.
But wait a minute. I don't understand. She has a drug issue, so she's disabled in your view. They ask her to take drug tests. Aren't they trying to help? Aren't they trying to deal with the problem, her disability?
Actually,
are they just supposed to ignore the fact that she's got a admitted drug addiction?
The issue we asked the court to consider is this. Were she actually a continuing drug addict, she could be dismissed. Were she a recovering drug addict or a cured drug addict, then they would be obligated to interact with her to find out if there's anything that you could do to keep her cured.
Did she ever assert such? That she was a recovering drug addict, or did she needed some accommodation for some claimed disability here?
No, Your Honor. But she isn't required to.
She denied drug use.
Correct.
It would be one thing if she said, look, I've got a problem, I need some help, and they weren't willing to accommodate her disability, so to speak. But she denied she had a drug problem, and then she was fired not for having a drug problem.
Correct.
There was no adverse consequence. She wasn't demoted for the drug issue. She was fired for taking the iPad without permission.
That is the accusation from the other side.
And your argument basically is that that's just a smokescreen, that they're alleging the theft of that, but the reality of it is we got to deal with the core of the disability first.
As I said, in the case of a person who is perceived to have been on drugs, and they did specifically test her for that. Now, the issue also is, if the court reviews the record,
Do you think it was improper for them to test her for that?
Not at all. That's why I said.
They asked her about her behavior, I think, on 2 occasions.
But that's the point about the inquiry about an accommodation, Your Honor. She was observed, and they did see things like crying, swaying, things like this. They sent her out for drugs, and they specifically told the people at the Quest Center they wanted them to look for what are called street drugs. They didn't find any.
But you know what I find is kind of ironic is maybe you'd be in a different situation if it didn't come back diluted. Diluted to me has a connotation to it. So if she had tested positive that day for it, then maybe you'd be in a position that whatever. But it was diluted. It appears to me it's someone trying to hide something, and you're saying, well, they were aware that she had this problem, they should have accommodated her. And as my colleagues up here have pointed out, it appears to me she's taken steps to hide that and never admitted to it and denies she had a problem.
Well, the thing is, with respect to the street drugs, that is not something she's ever admitted to. She denied it. However, as the complaint makes clear, she was at that time, and this is late 2015, early 2016, her mother was in hospice and was in fact dying, and she herself, Ms. Lepoliano-Keach, was actually taking medications both for that and for a prior injury to her back, which may have been what was responsible. Now, those are totally legal, and she was seen as having problems. Therefore, if they're going to test her for drugs, but these other problems didn't go away, I would argue that it was their opportunity, in fact, their duty under New York law, to inquire if there was a problem leading to these episodes in classrooms that had been documented.
It was the time between these inquiries, this behavior about the drugs, occurred about 10 months before the iPad incident, which was the basis of her discharge?
Yes, okay. and this is the other charge. Again, we argue that the failure to interact and try to reach an accommodation perceived drug disability, that in itself is actionable without adverse action. On the case of the alleged stealing of the iPad, again, we've pointed out that there is support for her claim that she was offered it. It never left the building. They knew exactly where it was, and nobody ever asked her, ever, what are you doing with this iPad?
Isn't that a separate claim for wrongful termination? If she didn't actually steal the iPad and it went down the way she claimed it was, that they had this side deal, she could sue for wrongful termination. We're talking about discrimination here,
right?
Not wrongful termination.
Well, in this particular case, she's had a history of being discriminated against because she has had issues with her family and whatever, and as a result of her issues in 2015, this moved forward, and they had followed her for the course of the next calendar year, shutting her out of things and like that, and she was treated in disparate fashion.
Thank you, Counsel. Good afternoon.
Good afternoon, Your Honors. May it please the Court. Kevin Lalonic for Respondent, Niagara Charter School. I just want to quickly respond to the suggestion that a perceived disability doesn't require an adverse employment action. It does. And as far as this whole perception of whether there's a disability, the Second Circuit, in interpreting the Americans with Disabilities Act, which New York courts have used to guide the interpretation of perceived disability under the Division of Human Rights Law, holds that sending an employee for tests based on reasonable suspicion does not amount to being perceived as disabled. And so we don't concede that there is a perceived disability here. And the only adverse employment action, as Your Honors recognize, was her termination in October of 2016, 10 months after she was sent for the drug test, and based on the theft of the iPad. The Division of Human Rights order is readily supported by a rational basis, which is the test on appeal, is whether or not the decision is arbitrary and capricious, and whether it has
supported by a rational basis.
Together with the statements of Tamika Morris, who says she did not give the petitioner permission to take the iPad. That provides a rational basis for the determination, and we request that the determination be upheld.
Thank you. 542, AJ v. Richer. Sorry about that. Good morning again.
Good afternoon again.
Good afternoon.
Yeah.
There are my mind is, right?
Well, the briefs were fairly extensive here. I do want to make a few comments. I'll try to abbreviate my point. This implicates Chapter 83 of the Amherst Town Code, and of course that is an ordinance or a statute which is adopted to impose liability on adjacent or abutting landowners with regard to maintenance of various responsibilities, including the sidewalk.
Excuse me, just to short circuit this, I mean, really what it boils down to is does plaintiff's property abut up to the sidewalk?
It abuts, the plaintiff's, the defendant's property, Hans Richter's property. Yeah, there's the county owns land, then there's the sidewalk, and then the street. So Richter's property abuts county land, but not the town sidewalk. The town sidewalk is separate and apart.
Well, let me ask you this question. We have, for all intents and purposes, we have a lawn. We can see in the photo, right? We have the sidewalk.
Right.
We have the lawn, which is the county's property, and then we have the road.
That's right.
Okay, so we got the sidewalk here. To that side of the sidewalk, whose property is that?
County.
Okay. And that's what you tried to establish through the surveyor and.
That's right, Mark Andrews. And you see, the point is this, it's kind of a slippery slope for the court to consider here, because you would say, well, it's only 3 or 4 feet to the town sidewalk from Richter's property with the intervening county-owned land. That's fine if it's 3 or 4 feet. But let's suppose it's 60 feet. Let's suppose on that section of Hopkins, there's a bike path.
See, I don't know if we have to go that far, because at least my reading of the testimony or the information from the surveyor, he references the county's property, correct me if I'm wrong, and it shows the flag where the concrete was raised.
Yeah.
And it shows the county's property abuts up against that. And I read that to be that the county's property abuts up to that side of the sidewalk, not necessarily that the county's property, that the defendant's property doesn't butt up against the other side.
No, the county's property does abut on Richter's side,
You're saying
as
it
well
abuts
as the
on
other
both
side.
sides. I
And
understand
that's
that.
what the survey shows.
Okay, well,
But you see, the problem with that is, if there is that small section, you say, well, it's 3 or 4 feet, and incidentally, the town sent a letter out, and he did put, this was about a half-inch raise, and he didn't replace the section, or what the surveyor called a flag, which apparently is a section of a sidewalk. I'd call it a section. Richter, out of the kindness of his heart, I don't know if that means that somehow he acknowledged or accepted responsibility.
I think we're making more out of it. It's as simple as process as this. Is the fact of the matter is, if the defendant's property butts up against the sidewalk, okay, then the defendant has a problem. If the defendant's property doesn't abut, then he doesn't.
That's my position.
And we have to look to see what the.
That's my position, and the second issue, I'm gonna short circuit considerably, because I dealt with it, and that's the issue of trivial defect.
Yeah.
It's the Trincherry case, and I've cited about 15 or 20 cases where the defects are essentially the same, half-inch, 3/4 of an inch. I'm not even going to mention any of the cases, other than to say, quickly, this accident happened on a sunny day in the spring, in full view of everybody, and it does not constitute, as the law requires in order to raise a question of fact, a nuisance, trap, or snare. And consequently,
we only get to that if we find that.
You'd only get to that if you would find that the property, yeah, but it's pretty clear on the survey that the county.
Like the old days.
You got Richter, county, and town sidewalk.
We have your argument, thank you.
Thank you.
Good morning, sir.
Good afternoon, Your Honor. And please the court, Philip Milch for the plaintiff. Your Honor, I think this thing has to be looked at as a whole. The property that is in question, the property of Erie County, was deeded to the county for the purposes of the town road. It's drainage and other services that were needed for Hopkins Road. So accordingly, the whole thing abuts, I think, to Hans Richter's property. In addition, Your Honors, the town of Amherst advised the defendant that it was his responsibility to take care of the sidewalk, and in fact, he took care of the sidewalk. He made the repairs that were necessary to correct the problem that was in the sidewalk. With regard to the trivial defect, Your Honor, the record is devoid, totally devoid of any specifics concerning the defect. The defendant did not come forward with any measurements, any calculations, any expert's opinion. The only thing that he has is an eyeball statement. It was approximately a half-inch raised, but it doesn't say how long it was, what the angle was. There was no proof that the defendant came forward with regard to the trivialness of this defect. The burden never shifted to the plaintiff to come forward and argue against that.
Thank you.
Thank you, Your Honor.
Frasca v. Legend Development, 543 through 543.8. afternoon.
Good afternoon, Your Honors. May it please the Court, Merritt Locke, Saunders Kaler, on behalf of, I'd kind of like to clarify how you'd like us to argue these. I am the original appellant in this matter on behalf of David Vickers, doing business individually.
We have you listed first.
Correct. I know that there has been a concurrent appeal that's been filed by the plaintiffs in this matter. I'd like to address the issues in my appeal. I'll do it within the 10 minutes and reserve. However you'd like me. How would you like me to do it, Your Honors?
Okay. You're going to argue everything you have right now.
Okay, so you want me to answer everything? Both of them. All right. So this is very extensively briefed, as you know. It's a very large record on appeal. There's been many different. So I'm going to specifically initially address the two issues that I think are most important on Mr. Vickers' appeal, which is what this case is about. This case initially was sued by the plaintiff. They commenced numerous actions with numerous different causes of action.
So you say you want to get right to the point, so
I do.
let's.
Okay. So the point is that my client, David Vickers, entered into a contract with the plaintiffs to build their homes. Within that contract, there was...
We know the facts.
Okay.
We know the facts. There's no question you know this enormous record better than us, but it seems to me the question is there a negligence cause of action that should survive against anybody?
The answer is absolutely not, Your Honor. There is no negligence in this case. There was a contract that was entered into. Within that contract, there was a warranty provision under Article 36A, and the plaintiffs...
So there's no independent legal duty. That takes
Correct.
out the negligence.
Correct.
With the warranty, that takes out the breach of contract.
Correct. So all we have is a breach of warranty here.
So, and that's really, the question is whether that cause of action was properly dismissed against Vickers.
And we believe that it was properly dismissed for numerous reasons. The first and foremost reason is that six of the seven, well, if we could start to begin, 6 of the 7 didn't timely commence this action. They were not within the 1 year and 30 days of when they moved into their homes with the certificate of occupancy. So all but the Trifficana plaintiffs, they have a timing issue here. For Ms. Frasca, she never sent a letter at all.
Right.
So she has a different issue, but still we think that precludes her altogether. The next issue is with this letter. So the letter that was sent specifically stated in the letter that my client was not going to be permitted.
And that was from Mr. Longaretta?
Mr. Longaretta, who was representing the plaintiffs 6 of the plaintiffs at that time, all but Ms. Frasca, specifically stated that my clients were not going to be permitted back in there to do any additional.
Twice.
Correct. Correct. So we believe, based upon that,
it defeats the warranty.
Absolutely.
Okay.
Any other questions for me? Thank you.
May it please the court, it was error for the court to set aside the verdict against Legends for negligence in drawing the lot lines, and error to set aside the verdict against Mr. Hogan for negligently designing and installing septic systems. With respect to the request or the argument regarding the Article 36 warranty claim, that does not apply to two-family homes. So they can't have it both ways. The definitions in the statute talks about single-family homes. As you know, there was a 302 versus 321.
Wait a second. You're saying so are you saying you don't have a warranty cause of action?
No, we're saying that we do have a warranty cause of action if we don't have a breach of contract or negligence construction cause of action.
Okay.
So the negligent construction cause of action, which was tried under Judge McRae, was based upon his dismissal of the breach of contract claim. The warranty claim, the warranty prohibition would not apply with respect to the timeliness because of estoppel arguments. Mr. Vickers said to each one of the plaintiffs, don't get legal counsel, I can cite you to the page, I'm going to fix it, I'm going to fix it, I'm going to take care of it. Instead, what he did is apply for a variance to have sprinklers put in. That variance was denied. In that application for that variance, they very clearly admit and that the firewall is insufficient, that the firewall is
Well,
not
there's
up
no,
to
there's
code.
no question. I don't think there's any dispute. I mean, I think there's proof everywhere that the firewall was a problem. It was not installed according to the engineer's plans.
Right.
So, but let's talk about the warranty, though.
Okay.
And Mr. Longaretta's letter. That seems to be kind of the main problem I see in the case. Mr. Longaretta seemed to make it very clear that Vickers was not going to be permitted to correct the problem. That letter was never withdrawn. So how does that not defeat the warranty claim?
Because well, first of all, it's in the context of the visit and the inspection.
No, it's not. It's before the visit inspection.
The letter requesting them to
Right.
to set that up.
Right. First you make the claim, then Vickers' lawyer sends a letter saying, okay, let me inspect, and I'll agree to do the repairs if there's a problem.
Right. I
Then
say that's
Longaretta sends the letter saying, okay, you can come and inspect, but under no circumstances are you going to be permitted to repair.
I understood and interpreted that letter, and I know he meant that letter to be on site at that point in time. But be that as it may, that whole argument becomes moot because look at Mr. Vickers' response. He sends them a bill. He says there is no problem. He says that, and does not propose a remedy. And the remedy that he proposed was soundly rejected, even by his own experts. So there's, I mean, what is he going to do?
So he was,
What's
after
he
he
going to
was
repair?
told he could not come out, he was not going to be permitted to do any kind of corrective work, after the inspection, he was obligated to go back and say, these are the problems, now are you going to let me do the work?
No, he sent them a bill. He sent them a bill
That's
for
not
the
answering my
inspection.
question.
Okay.
Was he supposed to go back and give a second, and ask them again, it would have to be the lawyer, are you going to permit me to do the work, or are you standing by your letter?
With a proposal for the repair.
Okay.
I would agree with that, yes. But as you know, I was not counsel at the time, so I don't have that much familiarity with those
You see,
circumstances.
the problem, I think, what we're getting to is that, you know, we have the warranty action, which was previously dismissed, correct? And summary judgment, okay? And we have the tort action, actually, the actions that went forward. If you're stuck with the warranty action, and you're saying, well, so somehow or another he's stopped from you saying that the time ran or filing ran.
Right.
And I guess the point that Justice Perdomo, I think, was attempting to bring out is the fact that how's he stopped? He said, hey, I'm here, I'm ready, I'm willing, and they get a letter saying, under no circumstances you're coming in. So why aren't they bound by the warranty?
The remedy that he chose was to seek the variance, not the repair. He went to the
What he
board.
did independently of that is what steps he took. The question is, he gets a letter from the attorneys representing the people saying that you're not going to be allowed to correct the problem.
Right.
And doesn't under that section, was it 36 or the warranty, doesn't it say that they have an opportunity, you let them up to at least come in and attempt to fix?
That does say that on that warranty, that's correct, on that warranty. However, the statute also says that if you're going to modify under 36B, then you have to set that forth clearly in the contract. If you're going to modify the provisions, and since the provisions only apply to single-family homes and/or condominiums and/or co-ops, then it has to be a single-family home, which ultimately the court determined, and the defendants made sure that through their application and variance process, that these are considered two-family homes. So they would have to, under those circumstances, put in the contract that they are adversely modifying the, or modifying the statute to include a two-family home. That you're not really buying or building a one-family home, you're building a two-family home, and we're going to make the warranty, merchantability, the 36B apply, even though it doesn't apply under the normal course. So there's no I guess it's a written warning.
So your argument is that the breach of contract, the bottom line is you've got a breach of contract case or cause of action, because Article 36B doesn't apply to this type of structure, and so the contract cause of action should not have been dismissed and
Right.
survives.
That's correct. The warranty, unless you find that the warranty provision applies to two-family homes. See, they can't have it both ways.
Why doesn't it?
Because under 777, a new home is described as a single-family home. So under the definitions portion of the statute, it's a single-family home or it's a structure of 5 stories or less that is sold under a condominium or a cooperative agreement, neither of which applies here, because these are not condominiums, these are not co-ops. These are single-family homes that they built in a setting called Raven Rock Estates. So the exclusion or modification or limitation under 36B has to be set forth in the contract itself, and a warranty that is sufficient to modify the implied warranty has to be announced to the party when they're modifying that. The negligent construction, of course, as you know, the contract itself is in 3 parts: the CCR&Es, the construction agreement, and the sale of the property. Those 3 parties in that contract included the buyer, Legend Developers, and Vickers. The CCR&Es set forth very specific requirements that they have to pay a monthly amount and so forth. But if you take a look at what the HOA did at that point in time.
Okay, are you talking about the negligence cause of action?
I'm sorry, I shifted, Your Honor. No,
Okay.
I was moving on to the HOA under the summary judgment claim. Unless you have something more you want me to address under the negligence claim. On December 17th of 2007, Mr. Carrier unilaterally amended the CCR&Es, and that's at, if you look at the record at 1906 and the record at 1899, it coincides with the same day as the Romanowski letter, where Mr. Romanowski announces that these homes are not to code, that they are violating, it's a fire safety health issue and so forth and so on. The same day, they purport to amend the CCR&Es based upon his ownership of 6 lots and be based upon the Article 10, Section 1007 of the CCR&Es. Well, that provision does not allow an amendment to the CCR&Es or the Homeowners Association rules and bylaws if it adversely modifies or affects any owner's substantive rights. What they did is they redefined
You're talking about Raven Rock or Carrier or both of them?
Legend HOA, the HOA, yes. Carrier, in his capacity as the president of the HOA. What he does is he modifies and he puts in the definition of unit and changes the insurance provisions under the fire provisions of the CCR&Es to allow the HOA to collect insurance premiums to insure the owner's homes. So now the owners are paying 2 premiums for their fire insurance, one to the bank that holds the mortgage and one to the HOA. So that amendment, I think, when that occurs in December of 2007, the same day as the Romanowski letter, demonstrates that they recognize that that liability laid there with the HOA. So additionally, the negligence in drawing the lot lines by Legend Developers, the jury found they were negligent. The jury found that it adversely and it caused damage and harm to the my clients, and they failed to.
But again, when we talk about negligence, there has to be an independent duty, a duty that's independent of the contract.
Right. And that duty is found in the code, the residential building code, that requires that structures be built to code.
Doesn't the contract require that? I mean, isn't that really just kind of a restatement of what the contractual responsibilities are?
The contract pulls that in, that's right. It restates those requirements in the contract itself.
Okay, so really what we have to determine is whether as you've stated it, whether there's a duty independent of the contract.
Right. And with fire safety issues and the code, I believe that that applies. Unless you have any other questions. Okay. Thank you.
Your Honor, I actually represent other defendants.
Okay.
Again, Merritt Locke, Saunders Kaler on behalf of Legends Developer, Robert Carrier individually, and David Vickers and Robert Carrier as members of officers and members of Legend Developers. If the court has, I think my brief is very clear. We believe that the court properly granted summary judgment as it pertains to Mr. Carrier individually and Mr. Carrier and Mr. Vickers as officers and directors of Legend Developers. So unless you have any questions on that, I would move to the next, which is we also believe that the court properly granted Legend Developers 4404 motion at the end of, after the trial, dismissing the claim of actions for negligence against it at trial.
Can I ask you one question
Sure.
about Article 36B?
Correct.
Does it not apply to this type of structure as stated by your opponent?
Article 36B does apply to this type of structure because it is a single-family home. Despite Ms. Bosman's stating that over and over again, there is absolutely nothing in the record on summary judgment that would establish that that is not a single-family home.
And
It
was that argument made below?
It absolutely was not made below.
Okay.
It certainly wasn't made on summary judgment, and in fact wasn't even made was made for the first time in the appellate brief.
Thank you.
May it please the court, your honors. Richard Lilling from Milgram Macris, Plusatis and Sidon on behalf of the Raven Rock Homeowners Association. We contend that the court below properly dismissed all claims against the HOA. They did not build, construct, design, sell these homes. Any claims of breach of fiduciary duty were explained and evidence was provided to support any decisions that were made by the board with respect to purchase of insurance to cover the HOA common properties and insurable interests of the homeowners association concerning public areas and whatever they were responsible for under the CCREs. We argue at the outset that appellants never perfected their appeal. My client was granted summary judgment in 2015, and it was a complete and final judgment as to my client. It was never perfected within the
The
time
only
allotted.
causes of action, I believe, that are part of the appellant's brief are breach of fiduciary duty and the general business law, the statutory cause of action, right?
Correct. And as to the breach of fiduciary duty, it focuses on only two elements: the formation of the Transportation Corporation, which was one of three options presented to the entire membership of the Homeowners Association. It was vigorously debated in an open forum, and everybody had a chance to weigh in before it was passed as the viable measure. And in terms of the general business law, that cause of action.
Well, these are allegations that really are unique to these plaintiffs.
Correct.
There's really not a showing of some sort of consumer-oriented
Correct.
conduct.
Thank you.
Good afternoon. It's Mark Halpin, and I'm representing Robert Carrier and David Vickers in their capacities as officers and agents of the HOA. And essentially, I think it's set forth in our brief, our argument. It's the plaintiff in their brief really just addressed the fiduciary situation, and there were two occasions with the Transportation Corporation, and there was mention about possibly three, the fire and casualty insurance, and also the assessment for green space. And I think our arguments are set forth there, indicate that we acted in good faith, was within the scope of the authority under the CCR&Es and the bylaws, and also it was within the legitimate interest of the HOA.
Thank you. Good afternoon.
Yeah, please the court. My name is Mead Versace, and I'm here on behalf of Hogan Engineering PC, who was the engineer on this project. And this issue regarding Hogan Engineering PC is limited to the issue of the septic tank specifications, which were done prior to the build. Now, those specifications were consistent with the standards of the New York State Department of Health. There was no testimony at the trial from any of the witnesses, including the plaintiff's experts and other witnesses, that there was anything wrong with the specifications.
And the court set aside the verdict
Yes.
along those lines, and you say it did so properly.
Exactly. So I have nothing further from here on. Thank you.